Good morning to you all.
Morning, Chairperson.
Mr. Soni,
Chairperson, today we are to hear the cross-examination of Dr. Pretorius.
Yes. Thank you. Mr. Salugazan, I see that there is a supplementary affidavit by Dr. Pretorius.
Yes,
Are you going to lead him in with regard to the supplementary affidavit?
Chairperson, that's what we wanted to inquire.
Yes.
That we place it before the commission. Because
Yes.
we've noted that the Galata group is also going to refer to it.
Yes.
So we'd ask, because it's quite a brief statement, it was filed
Yes.
on the 30th of July, that we lead him on it.
Yes.
So that it is placed on record and the Galata group can properly cross-examine him on the
Yeah.
evidence that's been made.
Yes, you may proceed.
Thank you. Mr. Pretorius.
Mr. Pretorius, you are reminded that you are still under your former oath.
Thank you, Chair. I'm still on.
Thank you.
Mr. Pretorius, you should have before you a file from the Galata group for your cross-examination today. Do you have that?
Yes, I've got that.
May I ask that you please turn to page 149 of that
I am
one?
there. Council, thank you. Commissioners, I'm there. 149, I'm there.
Could you please tell us what this document is?
It's a supplementary affidavit that I deemed necessary after listening to the Reverend Chikani and his evidence about the voter Basson matter and poisoning. And there's just a few factual inaccuracies that I felt it was important that I just bring out that factual inaccuracies. I don't fight with Reverend Chikani about it, but the poison list that's in there and the charge sheet is quite involved. So I deemed it necessary that I put in the supplementary affidavit.
Thank you very much. I suppose that covers paragraph 1 of your statement. Could you please read paragraph 3 at page 149 for us, please?
This statement is furnished in response to the following statements made by Reverend Frank Chikani in his evidence before the Commission, and then I quote the evidence. Reverend Chikani said, "Nobody up to today ever asked against whom were the rest of the other chemicals used. Nobody." And I published them in my book at the end. I refer there, it's in the transcript, page 19, lines 16 to 18. The second one that Reverend Chikani said, "It's only my case that is known. I have had people like from Netherlands coming to me and say, after hearing my experience, saying, you know, I have experienced something like this. Can I understand what happened to you?" That's in the transcript, page 20, lines 2 to 5 of Reverend Chikani's evidence. Then Advocate Soni asked him, "I just want to go back to paragraph 58. Do you know why voter Basson was not charged? Or why the charge against him was dropped?" Reverend Chikani, "Yeah, but that is what surprised me. Actually, when you read the plea bargaining, they put them on the suite. Voter Basson, but they charged, you remember, they charged voter Basson for other matters, and they wanted me to be a witness there, which did not make sense. But at that stage, it's now my suspicion at that stage, it looked like they were doing scores amongst themselves, the old order, you know, charged Basson for corruption. I think it had to do with corruption, etc." That's in the transcript, page 62, line 7 to 17, 3.4. "And the army was to deal with those outside the country and the police to deal with those of us who were in the country." That's in the transcript, page 20, lines 9 to 11. And the last one then, 3.5. "Sadly, I must record, no one came forward except for Paul Erasmus, who revealed in a newspaper article that he was responsible for putting me on the death list of the apartheid security police on the basis of instructions from his seniors. Unfortunately, Paul Erasmus was placed in a witness protection program, and we could not take this matter further. I've never understood why, if he was put under a witness protection program, the investigators could not reach him, because they should have a way in which they did, and they told me that they cannot reach him." That's the transcript of his evidence, page 41, line 30 to page 42, line 40.
Thank you. Could you then go to paragraph 4, which is your response to that which you've read previously?
I state here, Commissioners, I annex hereto as JPP 7 and 8 the indictment in the voter Basson prosecution, that's volume 2, being the drug, murder and conspiracy and related charges, together with the lys van getuies, the list of witnesses, forming part of that indictment as well as a translation of the charge sheet. Neither the indictment nor the witness list has previously been placed before the Commission. I invite the Commission to have regard to both documents in the context of the corrections set out below. The witness list confirms that Reverend Chikane was himself a witness in the Basson prosecution.
Thank you very much. And then for the Commission's records, the statement is without the annexures in this bundle, but it was, at least the indictment, referred to as the Basson indictment, was sent to the Commission on the 12th of August. So if that could just be noted
Yes.
on the record as the document to which Mr. Pretorius is referring. Could you then go to paragraph 5, starting first with the poison list and related matters? Could you just explain what it is you mean by the poison list?
There's a list, I think it's stated for Verkoper. That was a list drawn up by Dr. Andre Immelman. He was a veterinarian working at Roodeplaat Research Laboratories, and he had to give the super toxic to people of the security forces that was known by pseudonames, etc. And he didn't like that, so he drawn up a list of that Verkoper, of that list of poisons that he gave out. So that is the poison list.
Thank you. Please read paragraph 5 for us.
Commissioners, paragraph 5 reads, soon after the arrest of Dr. Wouter Basson on 29 January 1997 and the discovery of several documents relating to South Africa's chemical and biological warfare program in steel trunks, I began investigating poison murders and related charges together with, amongst others, Superintendent Niels de Lange of the Special Investigation Team. I consulted with a number of scientists in this regard, including Dr. Andre Immelman, the veterinarian and chief toxicologist of the Roodeplaat Research Laboratories, RRL, who reported directly to Dr. Wouter Basson. Dr. Immelman compiled in...
Sorry, can I stop you there?
Sorry.
You referred to a steel trunk that you discovered biological warfare programs.
Yeah.
Could you just expand on that to explain what the steel trunk is?
Three steel trunks were discovered shortly after his arrest from some of his associates. There were three
who's
steel
the rest?
trunks.
Sorry?
The arrest of Dr. Wouter Basson.
Thank you.
3 steel trunks were found at that stage, and inside were a lot of documents relating to South Africa's chemical biological warfare.
Thank you very much. You can proceed to paragraph 6.
Commissioners, Dr. Immelman compiled the poison list, which appears in the Basson indictment as Bailaat 2 to charge 63, because he was uneasy about the supertoxins he was providing to operators of the South African security forces. Dr. Immelman provided these substances on the instructions of Dr. Wouter Basson. Should I continue?
Thank you. Please go to 7.
Commission, I am aware that Dr. Immelman later visited Reverend Chikane at the Union buildings. He expressed regret for their participation in the producing of lethal toxic substances that had been used against him and disclosed his involvement in that regard.
Thank you. When you say you're aware that he later visited Dr. Chikane, Reverend Chikane, at the Union buildings, how did you become aware of this?
As I was working closely with Dr. Andre Immelman, obviously he informed me if he was approached by Reverend Chikane, etc. So I knew that he was talking to Reverend Chikane, but it was only after I've consulted with him and worked with him.
Thank you. Could you proceed to paragraph 8?
The poison list was incorporated into the charge sheet and the summary of the substantial facts in the Wouter Basson prosecution and forms part of the indictment annexed here to as JPP 9.
Thank you. Commissioners, again, it's not attached to the statement in this bundle, but it was sent to the Commission, if that
Yes.
could be noted. Please proceed to paragraph 9.
Paragraph 9, the poison list and subsequent investigation gave rise to the following charges against Dr. Wouter Basson, amongst others. Charge 57 was the attempted murder of Reverend Frank Chikane, alternatively conspiracy to murder at or near Jan Smuts Airport, April 1989. 9.2, charge 58 was a conspiracy to murder Enoch Knox Dlamini, May to June 1989. 9.3, charge 59 was the attempted intimidation of Archbishop Desmond Tutu, alternatively conspiracy to intimidate by means of a baboon fetus hung at Archbishop Tutu's residence in Cape Town in August 1989. 9.4, charge 60, that was a charge of conspiracy to murder Abdullah Muhammad Omar, Minister Dullah Omar, August to September 1989. Charge 61 is the conspiracy to murder SWAPO members at a refugee transit camp near Windhoek, Namibia, by contaminating the water supply with cholera germs. That was in August 1989. Charge 62 was a conspiracy to murder unspecified persons in the Eastern Cape by means of poisons beer. That was August 1991 to February 1992. And then charge 63 was an umbrella charge, the conspiracy to murder covering the full period from 1981 to 1992, incorporating all the individual charges from charge 31 to charge 62 by way of similar facts. Baylaw 1 to charge 63 lists the perpetrators and units in Coulomb 1 and the identified targets in Coulomb 2. Reverend Chikane is listed in Coulomb 2 alongside Paulo Jordan, Ronnie Casserols, Gibson Mondlane, Enoch Knox Lamini, Archbishop Desmond Tutu, and Abdullah Muhammad Omar, it's Minister Omar, amongst others. Baylaw 2 to the charge sheet is the poison list itself.
Thank you. I know that you will expand on what I'm going to ask at 10, but I just want to confirm the charges listed or referred to in these paragraphs 9.1 to 9.7, are these related to the poison list? Or at least let me put it as a question. How are they related to the poison list?
In the poison list, you would see, for instance, a baboon fetus was given to one of the operators, Chris Gerten Mani, or it was given to Koos. The other name that was used was Koos, baboon fetus. Paraoxon was given to Chris Gerten Mani, or digoxin. And digoxin is a thing as for your heart. It can be a poison for your heart, digoxin. So on the poison list, it appears there, digoxin, on 13 September 1989. And that's exactly the time that witnesses of the CCB said that they had to poison Minister Dullah Omar.
And the names referred to here in relation to the charges are the people to whom the poison would be administered. Is that what you
That
said?
was the targets, yes.
Thank you.
Yes, just the CCB is a Civil Cooperation Bureau, is that so?
Thank you, Commissioner. It's Civil Cooperation Bureau.
Civil, thank you.
Cooperation Bureau, yes.
Okay.
It sounds like an innocuous name, but it's not.
Thank you. Could you read 10 for us?
With regard to Reverend Chikane's evidence at paragraph 3.3 above, the charges against Dr. Wouter Basson were not limited to corruption and fraud. There were, in fact, two separate indictments against Dr. Basson. One dealt with the corruption and fraud, which was handled by Advocate Ackerman SC. The other, which I was responsible for, dealt with poison murders, conspiracy to murder, drug charges, and related matters arising directly from South Africa's chemical biological warfare program. It is the latter indictment that is annexed here to volume 2 of that indictment. It's headed dwelm, moord, samenswering en aanverwante klagtes.
Could you stop there and just translate that for us?
Drugs, murder, conspiracy, and related charges.
Thank you.
And contains the charges against arising from the poison list. It's therefore not to correct that the charges against Dr. Basson related only to corruption, nor is it correct that Reverend Chikane's role as a witness made no sense.
11 for us, please.
Come again.
11, please.
11. Commissioners, paragraph 11. With regard to Reverend Chikane's evidence as paragraph 3.1 and 3.2 above, it is not correct that his poisoning was the only case known or investigated from the poison list. Multiple charges arising directly from the poison list were prosecuted in the Basson matter, with named targets over and above Reverend Chikane. Those targets included a serving cabinet minister, an archbishop, an ANC operative, SWAPO refugees, and an unidentified persons in the Eastern Cape. The prosecution did not treat Reverend Chikane's case in isolation. It was presented as a part of a broader pattern of state-sanctioned poisoning operations conducted by a specialized unit of the security forces over more than a decade, which is precisely what charge 63, the umbrella conspiracy charge, was designed to capture. The poison list was central to that prosecution, not peripheral to it, and it was placed before the court as a formal annexure to the indictment. It should also be noted that although Reverend Chikane's book refers to 49 entries on the poison list, not all of those entries are poisonous substances. The list also includes items such as syringes, needles, and the baboon fetus, and a snake. 12, the prosecution furthermore went well beyond identifying individual incidents on the poison list. It pursued Dr. Basson himself as the commander of the entire chemical and biological warfare infrastructure through which the poison list was generated and substances distributed. Expert scientific evidence was laid before Judge Hartzenberg to establish the full scope and lethality of that infrastructure. Clinical toxicologist Professor Gerbus Miller of the Stellenbosch University testified that of the 24 items on the poison list covering the period August to October 1989 alone, at least 8 were extremely poisonous. 1, botulinum, is the most dangerous toxin known to man. It kills by respiratory arrest and is 1 million times more poisonous than arsenic. Another, paraquat, is so potent that even with the treatment for a low dosage, a 100% mortality rate can be expected. The court was therefore placed in a position to appreciate not only the individual incident charge, but the systematic nature of the program of which those incidents form part.
13.
Furthermore, and with regard to Reverend Chikane evidence at paragraph 3.4 above, it's not correct that the Army confined its operations to the outside the South African borders. The Civil Cooperation Bureau, a clandestine unit of the South African Defence Force, had an internal region of operations. CCB Region 6 conducted operations inside South Africa, and this is expressly reflected in the Basson indictment. The attempt to poison Minister Dullah Omar and the delivery of a baboon fetus to Archbishop Tutu's residence were both internal CCB operations forming part of the same prosecuted infrastructure.
14, please.
Commissioners, paragraph 14, most significantly, and with regards to paragraph 3.1 and 3.2 above, Reverend Chikane himself was listed as a witness in the Basson prosecuting, appearing as a witness number 147 on the lys van getuies, forming part of the indictment annexed to year 2. His own poisoning was directly an issue in those proceedings. His evidence before the commission that nothing was done and that his case is the only known case for the poison list is therefore difficult to reconcile with his own participation as a witness in a prosecution that addressed multiple cases arising from the same list. The commissioners respectfully refer to the annexed indictment and the witness list in this regard.
And then at page 154, you have a heading there that is Paul Erasmus. Could you just first explain to us who Paul Erasmus is?
Yeah, Paul Erasmus was witness Q4. He was one witness that came to the fore. He also gave evidence in the Ahmed Timol inquest. He was an expert in Stratcom, strategic communication. But he was a witness before the Goldstone Commission, and he's also written a book about the Stratcom, etc. Paul Erasmus, he was a policeman, and he worked at John Foster Square at a certain stage. So he was a policeman, and he was a witness that talked a lot about the false information that they sent into the community.
Thank you. Please read paragraph 15.
With regard to Reverend Chikane's evidence at paragraph 3.5 above, there is an explanation for why investigators were unable to reach Paul Erasmus. There was evidence before the Goldstone Commission that witnesses and associated persons were on a hit list and had left the country for their own safety. Paul Erasmus left the country together with Frank Dutton and me for his own protection. This explains why investigators were unable to reach him through ordinary channels at the relevant time.
Please explain which me you're referring to. Are you referring to yourself or someone else?
I'm referring to myself. I went with Paul Erasmus and Frank Chikane, and Frank Dutton to London and then to another country.
Thank you. And then your conclusion, please read paragraph 16.
Yes, this is important. With respect to Reverend Chikane, whose suffering under the apartheid state is not in dispute and whose perseverance in pursuing the truth about his poisoning is acknowledged, his evidence before this commission contains certain material factual inaccuracies that require correction for the sake of the historical record. The corrections set out in this statement are made solely in that spirit and with a view to ensuring that the Commission has an accurate and complete account of the Basson prosecution and the work that was done in that regard.
17, please.
The Commission is respectfully invited to have regard to the Basson Indictment Volume 2, including the poison list, bylaw 1 to charge 63 and die lys van getuies collectively annexed hierto as JPP 7, 8 and 9 in considering the corrections set out in the statement.
Perhaps as a matter of closing, do you confirm that that is your signature above JP Pretorius?
That is my signature.
Thank you very much.
Thank you, Commissioner.
Commissioners, that's Mr. Pretorius' supplementary statement.
Thank you. Ms. Moroka?
Butsof,
Butsofe.
Absolutely. And not for the record, please. Good morning,
Good morning, Advocate Moroka.
and thank you again for being helpful and being in front of us and for taking our questions, which probably you're going to say I repeat and why are you being asked these questions, but to be of assistance to the Commission, I want us to do a journey of a timeline from your involvement with the Rodriguez case up until you gave evidence and up until I'm cross-examining you today. Because I'm going to ask you a final question about whether your evidence has actually been of assistance to the Commission or not. So if I might just start off with a High Court case, another Supreme Court of Appeal case, that it is common cause that it was an application for permanent stay, correct?
That's correct, Commissioners.
And then if you go to page 25 of the Galata bundle, you see the names of the parties at the top.
Can you just give me some time?
It just, you don't need to, it's common cause that it was, the applicant would have been Rodriguez and the respondents would have been the NPA, the minister, that sort of. I'm not sure how I'm supposed to talk with this thing in my face. And that Mr. Kaji's name is not there at the start of the action.
Totally correct, Commissioners.
And that the NDPP was the first respondent.
I confirm, Commissioners.
And you filed an answering affidavit on the 3rd of December 2018.
I confirm,
And
Commissioners.
that we see from the papers that the Minister Masuta, filed an answering affidavit on the 26th of November 2018. I don't know if you recall that, but that's common cause.
I accept that, Commissioners.
And in both your answers, that is you and Minister Masuta, you don't deal at all with the allegation of interference because it's not raised in the papers by Rodriguez.
Correct, Commissioners, exactly, and I didn't think it's relevant.
But both you and the minister denied that Rodriguez was entitled to a stay.
It's correct. We could answer all the arguments.
And in fact, you deny that the delay is unreasonable.
Quite true.
And then on the 8th of January 2019, Mr. Imtiaz Ahmed Kaji then enters the fray, as it were, by intervening, and then the court allows him to intervene as a party.
I confirm, Commissioners.
He then, for the first time, refers to political interference.
That is correct, Commissioners.
But in his affidavit, he then explains that he relies not on his own personal knowledge, but on the affidavits of Ackerman, Mr. Ackerman and Mr. Piccoli that were filed in the Nkadimeng application.
I confirm.
You might not remember how it came about, but he files affidavits that he annexes to his own affidavit, where he alleges political interference.
I confirm, Commissioners.
You then respond to Kaji's affidavit. You do so on the 4th of February, 2019, wherein you accept that there was political interference, but that should not be the basis for the stay of prosecution.
I confirm, Commissioners.
You conclude that the delay in prosecuting Rodriguez was as a result of political interference or severe political constraints. And we find that, Chair, at page 101, paragraph 2.12 of the Kalata bundle. And this is, but in your answer to Kaji, you do not deny that the executive branch took steps to manage the conduct of criminal investigations. You do not deny that.
I confirm, Commissioners.
So in 2026, it's his affidavit that comes in. The position before Mr. Kaji comes to give evidence before this commission, the position is according to the papers, that Mr. Kaji made these allegations. You supported those allegations to the extent that you did not deny them. You denied the extent of inactivity or incompetence on the part of the NDPP and the NPA.
I confirm that, Commissioners.
And then if we move then to the Supreme Court of Appeal, where they dismiss Rodriguez's application, they also refuse that basically on the same basis, that, well, that there was political interference and that he should, and they then dismiss his appeal.
Say again, sorry.
In the Supreme Court of Appeal, there's confirmation that the stay the stay that was refused by the lower court is dismissed, that appeal, and there's also an affirmation that there was political interference based on the finding of the court a quo.
Correct, Commissioner.
In the court a quo, there's a statement that's made there that it's common cause that the respondents do not deny political interference.
You want to read that?
I will take you there. I would have thought it was common cause, Commissioner Home. That's what the court found.
Yes, you still haven't come up with a question. You are going to follow it up with a question.
He hasn't denied what I've put to him,
Yes.
Chair. The court of quo says in its finding, in particular, all the parties are in agreement that there was political interference and that such an interference may well have delayed the investigation and prosecution of the application. That's what the court said. And the question, if I were to ask you a question, would be that in the main, the court relied on your answering affidavit because that's what Kaji said and that's what you confirmed.
Oh, I differ from that, Commissioners. Yes, I accepted that there was political interference, but I did it on the strength of Advocate Vusi Piccoli's affidavit, and I did it on strength of what Advocate Ackerman said and what I experienced. So, yes.
I was asking a different question, and I'm sorry if you misunderstood me. the court ACO made a finding based on, I mean, that's what courts do. They base their findings on either viva voce evidence or paper documentation that's submitted. And I'm submitting to you that Mr. Kaji, after he'd been admitted as a litigant, said there was political interference. You said there was, I'm not saying where we're going to get there, to how and where we're going to get there, but at that moment in time, that's what the court relied on.
I don't deny it.
Because before then, there had been no need for the court to pronounce on political interference because nobody had raised it. It gets raised by Kaji and confirmed by you. In your answering affidavit, that is.
I don't deny it, Commissioners.
Thank you.
Switch off your microphone, please.
If we go to the ministry's position, remember Minister Masuta, as he then was, is the third respondent. The third respondent deposes to an answering affidavit. You might remember, we might not remember, you can tell us. My apologies, I'm told he's the second, he's the second respondent. Responds to what Rodriguez has to say and not what Kaji has to say, so it doesn't deal with the issue of political interference. Would I be correct in that?
I have no independent memory of that, but yeah, I don't dispute that.
It is only Rodriguez who then, Rodriguez accuses the NDPP and the Minister of concealing the true facts and alleged that Minister of Justice chose not to disclose material facts and that there was a deliberate decision not to prosecute, which you as a first respondent and the Minister, you representing the NDPP and the Minister then disputes. Am I correct?
I hear what you are saying.
So, and I know you say you do not recall, but at that moment in time before Rodriguez entered, no, I beg your pardon, Mr. Kaji entered the list, Mr. Masuta would not have involved himself with responding to questions about political interference because they were not, these issues were not before the court. That's the point that I'm making. And your first affidavit does not do that either.
You must not know the advocate Pretorius.
I agree, Commissioners. Chairperson, sorry, yes, I agree with that.
And at paragraph 43 of his application, Mr. Rodriguez himself says he has no knowledge of political interference. If you go to paragraph 43, you'd see that he says that himself. You don't deny, you don't take issue with that.
I don't take issue with that, Commissioners.
Then on the 6th of December 2019, Mr. Skosana, famously known as JB, deposes to an affidavit as an acting Director General of the department, as the second respondent. He also does not deal with Rodriguez's founding affidavit and the allegations that have to do with political interference. At paragraph 9 of Skosana's, if I can refer you to paragraph 9 of Skosana's affidavit, There's a small little bundle before you, and it's called Index to Extracts from Pleadings in the Rodriguez Matter.
Which page?
It's paragraph 9 of Skosana's affidavit. And at the top, there are red numbers, and it's marked page 20. Have you got it?
I've got it, thank you.
And at paragraph 9, Mr. JB says, applicant has not, in this application, set out how any further details of political interference would affect the outcome of the matter. There is an absence of any averment that any further detail will enhance the prospects of success of the appeal. Do
I
you
see that, Commissioners.
Thank you.
I'm still waiting for the question.
The question is, you agree that, if you recall, you were involved in this case, and these were the papers that were before court. And these are the averments that were before court, from both the first and the second respondents. That's what I'm putting to you. The answer might be you don't recall.
Yeah, you must also remember at that stage, I think my health was not very good. I was still under treatment for some stages there at that stage. So I hear what you're saying, and I don't dispute, because I've been criticized at that stage that I tried to keep quiet the fact that there was a long delay, and said I deliberately withheld it. And that's why in my statement to this commission, I tried to explain why Advocate McAdams' affidavit wasn't filed firstly. So I think we're on the same track here.
And just for the record, I offer no criticism. And likewise, the Supreme Court of Appeal essentially relies on the papers, relies on what Kaji has to say in the papers and what the NPA has to say in the papers in the form of your affidavit. Am I correct?
I hear what you're saying, yes?
And then,
Are you re-arguing the case, and are we reviewing these cases?
I'm doing much more than that, and you will hear in argument, Mr. Komo, what we have to say about that case. But we are putting the facts before this commission of what the court relied on. Because you then come to this commission, which is tasked with a particular mandate. You and Mr. Kaji come and give your evidence on the facts as you know them, and the facts that you relied on in the Kotako and in the Supreme Court of Appeal. Am I correct?
I agree, Commissioners.
You state in your affidavit that you believe the versions of Advocate Piccoli, Mr. Piccoli, and Mr. McAdam, and you have no reason not to.
I confirm that, Commissioners.
You also, in the transcript at page 5, line 9 of your evidence, refer to this belief that you held And you also referred to the secret documents that you found.
That Advocate McAdam found, Commissioners.
Can I just ask you this? Do you know about MIS, the handling of official documentation in government?
I know about it, Commissioners.
And that those documents would have been marked that way in terms of classification, not in terms of that they're secret documents.
I'm not so sure that I quite follow what
Every
you say.
document that is handled in government is given a classification. It is either for public dissemination, it is secret, it is top secret, it is there's a misgrading of documents.
That's true, Commissioners.
So that therefore when you say you found documents that are marked secret, it was not because they are secret documents, it's because they are documents that are marked secret. That's the point that I'm putting to you.
Difficult for me to see the differentiation between the two. If it's marked secret, it's the misclassification for it, and obviously there was some sensitive stuff in it.
That's the point I'm making.
Okay, then I accept it.
Thank you. You then, in your affidavit, you speak about Advocate Pikoli's nuanced approach to the prosecution policy and or guidelines. That's what they were called, guidelines. You were not involved at all in the formulation of these guidelines. It was long before your time. Or it was not before your time, but you were not involved during that time.
That's true, Commissioners. I was not involved.
Sorry, Member Doc. Commissioners, may I ask that we be directed to the volume, the page,
My apologies.
and the paragraph?
My
Yes.
apologies. It will be the transcript by Mr. Pretorius. So it is transcript page 5, line 9. And it starts at line 9, where it says, it was necessary because I did not have personal knowledge of political interference. Obviously, I worked with my colleagues and I lived through it. And further down the line, it says, so I have to refer to Advocate Ackerman, Vusi Pikoli, Advocate Pikoli, and Chris McAdam that found some of those secret documents. That is why I had to refer to them, because I do not have personal knowledge, but I verily believe their version.
That was my evidence, Commissioners.
Thank you. You also do not know of the differences that occurred in interpretation about guidelines and about mandates and powers between the police and the NPA. You were not there during that period.
No first-hand knowledge of that, but I had to apply the guidelines when I considered the representations being done by Chris, Gert and Mani. So I take note of them, but I was not involved in working on those guidelines at all, or the task team.
And maybe just a small point, Mr. McAdam, in his evidence, his transcript of his evidence, at page 57, line 3, says that he did not use the words political interference. It might just have been Mr. Piccoli and Mr. Ackerman, but definitely he says he was not.
Quite possible, Commissioners. I
Thank you.
don't differ from that. It's quite possible.
He says, if I may say, because I'm going to be asked, I did not mention the words political interference at all in the matter. I merely set out facts and documents that I had first-hand knowledge and documentation which the NDPP's office manager had given to me, which belonged to Mr. Piccoli. You take no issue with that, you don't know.
I
Thank
take
you.
no issue with that.
Thank you. Finally, Mr. Pretorius, if I could just get to the terms of reference. And I'll get there, but before I get there, if I could ask you, did you ever have sight of Mr. Dumisansebeza's report to the NPA?
No, Commissioners, I did not have sight to that report.
Where Mr. Nsebeza suggested that there must be information gathering investigations done as to who, how, when political interference occurred. You wouldn't know that. But what you do know, I would imagine, is that to your knowledge during your tenure, there were no investigations that were done regarding political or interference or the allegation to stop prosecutions.
I confirm that, Commissioners.
Because I'd want to say, if you want to conclude political interference, you'd have to do the investigations as to who, how, when, why.
Yeah, as an ordinary human being, obviously I rely on what Advocate Ackerman said, how he was stopped to go forward with the prosecution of Chris Gert and Mani. And there was no prosecution. So factually, I could see the prosecution that was ready didn't go forward at that stage. And just after that, I see new policy directives being there. So obviously, if Ackerman say, yes, Jan Wagner phoned me and said you'll get a phone call from Department of Justice, and just after that he got that phone call, I believe him. So yes, in my mind, I believe him.
But you would agree with me that, or you don't know that Mr. Piccoli was the one who, not conceived, but was a driving force with reference to those guidelines that you refer to.
I only learned that later. Obviously, with the litigation later, Nokutula Simelane, well, I've read in the press, in the media, that they made affidavits. And obviously from that time onwards, I've seen Advocate Piccoli and Ackerman has made affidavits. And then I learned it. But at the time it happened, I was not privy to that. I didn't know the nuances at that stage. The discussion between Ackerman and Jan Wagner, I was not privy to it at that stage. I only found that out much later.
So if I say to you, and with the greatest of respect, because I personally know of your work and your contributions to the fight to get to the truth and to hold people accountable. And in the commissions of inquiry we were both involved in, I would say to you, having regard to your evidence before this commission, that you are not able, as a matter of fact, to be of assistance to this commission in regards to the question that has been posed in the terms of reference as to, how are the terms of reference phrased? Who stopped prosecution of TRC cases? That you can't answer. And that you can be helpful with.
To a certain extent, Commissioners, I agree. I have no personal knowledge of that at that stage, but as is clear from other questions, I was also not oblivious that was happening around me. And initially, I think it's Advocate Nalani that contacted me to hear if I can help, and I told him, no, I don't have personal direct knowledge of who stopped it. So Advocate Nalani did contact me in the beginning of this, and only later on did I receive a Rule 33 when Imtiaz Kaji pointed me. But in the beginning, I did talk to Advocate Nalani and said, I don't have personal knowledge of that. So to a certain extent, I agree with you. But I'm also not oblivious what happened around me. There was no prosecution of Chris Gert in money in 2005. It only materialized in 2007. And then after the World Cup in 2010, we've got three investigators looking at those things. So I lived through those times. So the effects and the lack of political will to provide investigators, I lived through that. I lived through that. So in a certain regard, I agree with what you state to me. But in another way, I'm not oblivious to the fact what happened around me and that Advocate Ackerman has been taken away from those things. So that's my answer.
But you are not able to say who. When you talk about political will, who led that political will?
I agree with you. I agree with that, Commissioners.
You are not able to say, because can I read what and I accept what you say about the lived experience. The terms of reference says, inquire into whether, why, and to what extent and by whom. That's all I was asking you then. Those questions specifically targeted at your evidence, you're not able to do that.
I agree with that statement. I have no personal evidence about that, no direct knowledge of that.
But what you do have, and that would be my final comment to you, it's not really a question, is that you put your all in what you were supposed to do in the work that you did.
Thank you. I accept that. Thank you, Commissioners. Thanks.
That would be all our questions.
Thank you.
Chair.
Thank you, Ms. Moroka. Mr. Vani? Mr. Vani, would this be an appropriate time to adjourn for tea before you commence your cross-examination? Yes, so that it's not interrupted midstream.
Yes, Chairperson, I think that is
Yes.
appropriate.
We'll adjourn for lunch until 11:15. For tea. For tea. We're having an early lunch today. Yes, Mr. Vani?
Thank you, Chairperson. Mr. Pretorius, welcome back to the Commission. And as my learned friend from the Minister said, we are grateful to you for coming back. We understand that you're in retirement and it's now time to spend precious time with family, so we're hoping that this will be the last time you have to appear.
Thank you, Speaker Zwane.
I should disclose to the Commission that you and I actually have a prior history going back many years. I was actually trying to think when we first met, and I think it was when we had meetings back from about 2005 onwards at the NPA offices or the PCLU offices in Silverton with Ackerman and others. And then, of course, we worked together on certain cases, most notably the Ahmed Timol case, where you were lead prosecutor for the state and I was lead counsel for the family. And I wish to thank you for your collaboration in that case, and I believe it was the collaboration between the state and family that resulted in a successful outcome in that case.
Thank you. Thank you, Council.
I also want to thank you for the work you did in getting the Neil Aggett case reopened. I also want to place on record that we do not align ourselves with the criticism levelled at you by MTR's Kaji in relation to the Basan and Timor cases.
I take note. Thank you, Council.
So we've given you our questions and we're going to follow them fairly closely. Can I just check, do you have a copy of them? Cross-examine, Chairperson.
Yes.
Thank you, Chairperson. And we wish to track your career and then pose questions at different stages of your career. And we have summarized your career trajectory at paragraphs 5.1 to 5.6. Your time at the Goldstone Commission from 91 to 94. You then became a deputy DPP since 95. You spent a period at the DSO until being transferred to the PCLU in 2003. You were a member of the PCLU since its inception in 2003. You were the special director of that body between October 2015 and March 2019, and then you retired in May 2022. Is that an accurate overview?
That's correct, Commissioners.
All right, then let's turn to aspects that arise in relation to the TRC cases. And here I'm dropping down to 6.1. In paragraph 12 of your statement, Commissioners, the statement is in the bundle. It runs from, I believe, page 1. You state at paragraph 12 that during the early 1990s, you received information from various sources concerning a range of matters, but not in relation to the Timor or Craddock 4 cases. Can we ask, did you receive any information in relation to other TRC cases?
Yes, I'll elaborate on that now. The definition of a TRC case, just interesting, but yes, I know what we mean here. What I stated previously, I did receive information about the Smith murders. So I did receive information there. I also received information on the Samora Machel air crash. And in the Pierre Steyn inquiry, there was a lot of allegations there about a coup d'etat and a lot of things there. I was also involved in the Helderberg inquiry for some time, and later on it was taken away and given to John Welsh. I had also worked on the Anton de Bosque matter. For some time later on it was taken over by Advocate McAdam.
And in the Ferdi Barnard case, the journalist, the Wet Potgieter, brought the witness over the weekend to my house, and we started working from there. So yeah, there was a number of cases that can be described as TRC cases that I worked on.
Thanks for that clarification. Just a small housekeeping matter. When I pose a question, you're free to look at me, but when you give the answer, you should address yourself to the commissioners and the chairperson.
I apologize for that, Commissioners.
And in that period, 1995 to March 2003, at what point did you become a Deputy Director of Public Prosecutions?
It was in 1995, Commissioners.
In 1995, okay. And during that period, is it this period in which you worked on the cases you've just described?
Yes, that's correct, Commissioners.
Were you aware that an indictment had been drawn up by Advocate Ackerman against former SAP General Isaac Johannes Krappies Engelbrecht during the 1990s?
No, Commissioners, I was not aware of a specific charge sheet that was drawn up by him. I worked at the Oliveira investigation team, and Anton was kind of independent from that, but I was not aware. But it was quite possible because we had some information of the involvement in the generals. In the Yapi Maponya case, for instance, the one general was called Maponya Leroux. There was quite good evidence that the petrol book in Krugersdorp was taken by the generals. So I was not aware of the charge sheet, but it's quite possible. I won't dispute that it was there. I think it's probable that it was there, Commissioners.
And then we heard from an investigator by the name of Andrew Leask. He said there was a decision made to connect the Nakatula Samalani case to the Engelbrecht matter. Did you become aware of that?
Yeah, I think he said I gave the information. Mike Holmes is also the guy that investigated the Chris Hani docket, and he was successful in the Chris Hani. So Mike Holmes was also there. I don't have an independent memory of that, but it's quite possible that I would have instructed Mike Holmes to get similar facts so that we can prosecute generals. From the beginning, the emphasis was also to get the generals. Even in the Goldstone days, when we approached Eugene de Kock, we wanted evidence against the generals. So it's quite possible that I told Mike Holmes that evidence should be put together for similar facts to prosecute the generals. Not to the detriment of Coetzee, Mong, and Pretorius, but that it's quite possible that I could have told Mike Holmes, we got to need that similar fact evidence to prosecute the generals. It's quite possible. So I don't dispute what Andrew Lee said about that, but not to the detriment of the case.
Thank you. And just a reminder to speak to the commissioners.
Commissioners.
A bit difficult.
Quite true, Judge.
And can you speak to the decision by the DPP in Pretoria? We believe that was then Advocate Silas Ramayeti, his decision not to prosecute General Engelbrecht.
Yes, Commissioners, I can speak to that. I've seen documents, email specifically that I've seen and that I have relating to that matter. Dr. de Oliveira decided that the docket against General Krappies Engelbrecht must be decided by the Pretoria office. I'm not sure exactly why. I personally would have preferred if it stayed with the people that work on the Eugene de Kock prosecution. We worked with Q1, Q2, Q3, all the witnesses in the Kock matter. Your ordinary DPP office don't usually work with the Section 204 witnesses like in the Wouter Basson case or like in the Eugene de Kock case. Usually it's witnesses that themselves is guilty of murder. Pamela Moses and Tere Lang in Eugene de Kock's case, the guy that did the tubing in the bar was a witness, and your ordinary prosecutors at the DPP office don't usually work with witnesses who were themselves involved in murders, etc. Even in the Wouter Basson matter, where Donnie Fall had to kill his colleague, and he bent the spoon like that, you work with witnesses like that. So I'm a proponent of the centralized system, that you keep that at the task team where you work with this type of witnesses. So the document that I saw about General Engelbrecht was done by Dries van Rensburg. He and Rita Meintjes had decided that docket, and their judgment from the evidence was there was no prima facie case, and it was supported by Ramaite. The DPP supported their decision that there was no prima facie case. You can't just review that case. If they didn't comply with the policy directives and something like that, you can't just review such a decision. I didn't agree with that decision because that gave rise to selective prosecution of the Kok. I felt he's the only fall guy that was prosecuted, so I didn't agree with that decision. And I thought that there was enough evidence that the generals, or some of the generals, could have been prosecuted. But it's like in the Els and the Sons matter in the Ahmed Timol case. Once it's taken out of...
Kyk bietjie in hierdie rigting.
Sorry, Commissioner. Sorry, Judge. I'll do that, Commissioner. And in the Els and Sons matter, also in the Rodriguez matter, Commissioner. Once it was decided, I can't decide that anymore, it was sent to the Pretoria office. Or even the prosecution of Rodriguez was sent to the Johannesburg office. Then it's their discretion. I can talk to them about it, but I can do nothing about that. So this was sent to the Pretoria office. Dries van Rensburg and Rita Meintjes decided that, and the DPP agreed, Commissioner, with that. And so I can't just review a matter like that. But I've given you my opinion on it.
Thank you. And thanks for that clarification. And since you have spoken to the Eugene de Kock case, perhaps we can just jump to that and deal with it at the same time. You were part of that prosecution team that secured the conviction of Vlakplaas Commander Colonel Eugene de Kock. And as you've pointed out, there was this expectation. There were certain individuals up the chain of command. We've mentioned them in paragraph 8, aside from Krappies Engelbrecht, Basie Smit, Nick van Rensburg, and Johan van der Merwe. And we've pointed to an extract from the judgment of Justice Willem van der Merwe, where he said that de Kock did not act alone, his crimes were committed on the orders and with the knowledge of senior police officers, and enabled by a broader command structure. We quote further, a rotten system allowed de Kock to commit these crimes. The same system approved of his actions or did not disapprove of them and helped him to conceal and continue with his crimes. So, as you pointed out, there was certainly an expectation that further prosecutions would follow. Now, you have indicated your views on the matter, which differed somewhat from the DPP Pretoria office. So perhaps I can pose the questions that we highlight in our paragraphs 11 and 12 of our application to cross. And let's just focus on paragraph 12. Is there any reason why the NPA didn't use de Kock as a witness, given the disclosures he made to the TRC and the fact that we know he was cooperating with the missing persons task team?
Commissioners, that's not accurate. We did work with de Kock. Even while the case was going on, I got instructed by Dr. De Oliveira to go and start working with de Kock. So I worked with de Kock and I got a lot of information from de Kock. I would believe that in the docket against the generals, there could have been statement from de Kock in that. And in the Motherwell case, he was crucial So we did work with the COC. And wherever the COC had information, he did supply it to us. I can remember quite vividly, clearly, that I made lists, and over a weekend I got the whole de Oliveira investigator team at my house, commissioners, and I gave them the information. So we did work with the COC, and he was not unwilling to work with us. And he provided us with information.
Thank you for that clarification. Let's then turn back, and we were just tracking your career. If I can draw attention to paragraph 6.3. So in the period March 2003 to March 2019, you were still a member of the PCLU. Apart from the TMAL and agate inquests, did you work on any other matters that could be described as TRC cases during that period?
Yes, as I alluded, commissioners, and sorry if it's a repetition, the Smith murders. From time to time, when I got some investigative resources, I did work on the Smith murders. That case was closed a number of times by the PCLU management. Advocate Ackerman, he wanted getting things done, so he would decide priorities. So the Smith murders was closed, but when I got information, I worked on it. I worked with Noel Zeeman and Tolly Vreugdenburg, the guy that did the Boerenmacht trial commissioners. So from time to time, I did work on the Smith murders, and then I submitted a memorandum in October 2021 on that matter to Rodney de Kock, the late Rodney de Kock, and Andrea Johnson. I also worked on the Samora Machel matter. It was assessed that there was no reasonable prospect of a successful prosecution at that stage. Except for the cases that you refer to, the Timol and Agate, I also worked on the Hafiji matter, as you know, and that was the foundations, commissioners, where we had this monthly accountability meetings. We got 10 more cases or a dozen more cases from Weber and Wenzel that we had to look at, like the Kraddock 4 matter. So then we started to work on that, and we had some investigators from DPCI, CATS, Crimes Against the State. So we started working, and the foundation was laid for the later developments. That's about what I can remember now on the other cases that I did work with. I can just for completeness sake say the Helderberg matter was taken by Minister Dalla Omer, and it was given to John Welsh, commissioners, and they concluded the matter. I was not involved in the Helderberg after that.
No, sir.
The Smith murders, I think the wife was Cora Smith, if I remember well. What were the allegations why they were murdered?
It's a difficult question, Commissioner, in an open court like this. I would think the info scandal possibly give us the biggest reason, and some people would have lost their positions. They would lose their positions, and I think that's why that was done.
Yes, and Judge Moster did not make any findings, or did his investigation not touch on that aspect? You remember Judge Moster?
I remember Judge Moster,
Tiger by the tail?
Commissioner, but I'm not so sure. I don't want to speculate. I don't have a clear recollection as to exactly the Erasmus Committee and Judge Moster's committee, what exactly that was. I concentrated more on the persons of interest, the possible suspects that I worked with, and not so much on that. So I'll be speculating. So
Okay,
I'll be speculating there, Commissioner.
Thank you.
Thank you, Commissioner. And perhaps just to follow up on Commissioner Comer's question, the Smith matter was never taken forward. Is that because we simply didn't have a viable case against anybody?
After I've submitted my memorandum where I recommended the reopening of the Smith inquest. I don't know, I never received an answer from Andrea Johnson or Rodney de Kock. I don't know Shabnam Singh, what is their decision on that matter, but I made a recommendation there.
Thanks. And apologies for asking you to repeat yourself. I was under the impression that those cases were mainly 1990s, but they did spill over into subsequent decades. Let's then turn to the prosecution of Basson. That's on page 4 of the application, paragraph 13. And as I mentioned, we offer no criticism in relation to the role of the NPA on this prosecution, but we want your assistance with some technical questions. So we know, for example, that the High Court quashed 6 charges that the NPA had posed against Basson under Section 18.2 of the Righteous Assemblies Act. And on appeal, the Constitutional Court set that aside and reinstated the charges. And the court left it to the NPA to determine what steps it wishes to take in respect of those charges. And I think you have answered this before, but I beg your forgiveness, I can't remember the exact answer. Why was the NPA not able to reinstate the charges?
Commissioners, there's 2 main reasons why that was not feasible and not attainable at that stage. First, the evidence that related to that 6 quash charges was presented to the court, and that's also the reason why in my supplemental affidavit I provided the indictment, the charge sheet, and because it's quite an involved charge sheet. If you look at that charge sheet, charge 31 there is an umbrella charge, a conspiracy relating to 1981 to 1988, and there's the killing by Barnacle or D40 of their own members or people that they regarded as enemies of the state. But it's got similar facts. It's for a whole period from 1981 till 1988. And then if you go to charge 63 is once again an umbrella charge, but that one only relates from 1981 till 1992, and that relates a little bit more to the alleged killings by the CCB and all the individual things there. So the evidence on that 6 charges was laid before the court because it was relevant for these umbrella charges. The umbrella charge encompassed all those actions into the one charge, both at the end and at the end of the indictment. So that evidence was laid, and the court did not believe the state witnesses there. So firstly, the plea of ultra far acquis can be used in that specific regard. Consent, the evidence was laid, it was part of the umbrella charges, and still the court, with all the similar facts, didn't believe the state witnesses. That's the first reason. But the second one that was more difficult is I work with those witnesses, and those witnesses are Dani Val. Now, Dani Val was one of the main hitmen of the CCB. And it was not easy to convince him to come and give evidence, because he had to give evidence how he killed his own colleagues that had brain cancer and was talking out about the sensitive operations, and then he bended that teaspoon and things like that. And in my office he phoned Joe Verster, the head of the CCB. And Joe Verster told him, those guys are going to take out your intestines and then they're going to throw you to the wolves. But I convinced him. I convinced him to give evidence. And we also have Johan Tron. Johan Tron is the other big witness in this regard. And Johan Tron is the clearest illustration of what mattered. Having given his account in court once, Tron consistently refused to do so again. He declined interview request by telling the media he made a covenant with God and would never speak of these matters publicly again. So it was very difficult to get that CC members to come and talk about the murders that they were involved in. 3 weeks after the judgment in the Basson matter, the court refused indemnity, Section 204 indemnity to Johan Tron, Dani Val, Trevor Val, Mr. K. Also Kobus Botma and Grant Wenzel, but that's not relevant for now. But Johan Tron, Dani Val, Trevor Floyd and Mr. K was central to these quash charges. So there's no way that I could convince these witnesses to come and give evidence again. It was just not feasible, and they will not give evidence about them again. So I did not have the evidence, and the question of autrefois acquis also came in because of the umbrella charges.
Thank you.
Commissioner, sorry.
That detailed explanation then also explains the next question, why the Constitutional Court judgment came too late. Then let's move to the meeting that you and Advocates Ackerman and Chris McAdam had with General Ray Lala, National Head of Crime Intelligence, on 25 August 2003. Am I correct in saying that this meeting was set up in order to plead with General Ray Lala to facilitate or assist with the provision of investigators for the TRC cases?
It's correct, Commissioner. That's why it was set up. Chris McAdam knew him well. They worked previously, so Chris knew him well, and it was set up for that, Commissioner.
And can you explain why you were part of that meeting?
I was part of a small unit, and so I joined Advocate Ackerman and McAdam going there. I didn't have a big role, and as Advocate McAdam gave evidence, he said to us, let me do all the talking. So I really played no substantive role. I really played a minor role by going there. I didn't play a role. And as Ackerman said, let me do the talking, and he did the talking.
Do you recall whether towards the end of the meeting, Ackerman mentioned that he still needed to take a decision in respect of the ANC 37?
No, Commissioners, I don't have an independent recollection of that, but it's quite possible.
And I understand you were also called in with Ackerman and McAdam into the office of NDPP in Guka when the three of you were confronted with the Lala tape that General Lala had clandestinely recorded. Can you give an account of what you recall about that meeting in NDPP in Guka's office?
Yeah, it was embarrassing, Commissioners. Advocate Nguka was quite angry with us, and we were made to sit and watch the video again. Advocate Ackerman badmouthed the Scorpions. He really badmouthed the Scorpions, and Advocate Nguka didn't think it was necessary that he badmouth his own organization like that, so we were made to watch this video, and he was cross with us. He was angry with us, Commissioners.
And were there any particular repercussions that flowed from that meeting?
Commissioners, not really. Ackerman has written a letter to Commissioner Ray Lala, so he written a letter to him, and that about is it, but there was no real big significant steps taken after that or real repercussions.
And in relation to the frustrations that Ackerman expressed to General Lala, are you of the view that those frustrations were justified?
Yes, no. Later on I'll also refer to it. There was a conference in 2006, the TRC 10 years on. Yasmin Suka was also at this conference, and I also was a speaker there, and in this speech I dramatically said, my kingdom for an investigator. So yes, I agree with the frustration that was there, so yeah.
So certainly at that time, you were aware of the struggle to have the cases investigated. Were you also aware that there was this fear or concern on the part of the police that the NPA might be pursuing cases against the President, Mbeki, and the ANC 37?
I think that has been misused, but yes, I was aware that was a fear. What one can add, sometimes there was informers also working with the old security police, etc. So I think there was also a fear that the informers would be disclosed and things like that. So it's not just the ANC 37, but yes, I was aware. The disclosure of informers was also a real fear that I think that was there. But I didn't have hard evidence about that, but I knew that that was misused or abused for other purposes.
And sorry, when you say informers, what do you mean by that?
People that work for the old security police at that stage. And in the old apartheid days, and that they would be disclosed. So there was also a fear of that.
Thank you. Let's turn to the next topic. That's also on page 6 of the application, which is the Vlok and Van der Merwe plea deal. So we're aware from the evidence of former NDPP advocate Bekoli that in February 2006 he instructed you and I think others to review the representations made under the guidelines. These are the prosecution policy amendments by Smit, Otter, and van Staden. This was in respect of the Chikani attempted murder. Do you confirm that you did get that instruction and you did take part in that review?
That is correct, Commissioners. Advocate Bekoli did ask me, and yes, I reviewed it. I tried to get documents relating to that. I went to the NPA's offices and I tried to get documents. I could not get documents because I can't remember who was the team who was working with me. But I know I led that team and I said they're not disclosing the full truth, therefore don't heed their request for their representations. So yes, I advise Advocate Bekoli on those.
Thank you. Do you recall who else was involved in the review?
I really racked my minds. I think the policemen that worked with me, Niels de Lange, Colonel Niels de Lange, and Piet van der Merwe, some of the policemen that worked with me on the poison murders, that I assisted and enlisted their help to tell me whether they think that the full truth was disclosed. So I think those people helped me in that regard. But I can't find any documents to support that. But I know, I lead it and I told Advocate Bekoli, this guy is not telling us the full truth.
And were you also involved in the review of the subsequent representations by former Law and Order Minister Vlok and Police Commissioner Van der Merwe?
No, I have no, Commissioners, I have no independent recollection of being involved in that. I know in the voter Basson matter, I approached General Van der Merwe and he refused to cooperate with me. I've got a vivid memory of that. I would have thought that if I was involved in seeing Minister Vlok and General Van der Merwe later on in these representations, that I would have known. But I've got no memory that I've ever seen them or worked with them. In fact, I've heard some facts in this commission that I didn't know about Strydom and things like that. I knew nothing of that.
Thank you. At that time, do you recall Advocate Ackerman refusing to participate in the review because he felt that the prosecution policy amendments were unconstitutional?
Yes, and I've also listened to the evidence here, obviously. I know him and Advocate Chris McAdam. They worked more closely with that, and I know they felt it was unconstitutional.
So subsequently, we know that the representations were rejected under your advice. That happened in July 2006. And then, of course, the subsequent plea and sentence agreement is on the record. Were you involved in negotiating that plea and sentence agreement?
Commissioners, no. I heard it when Advocate Ackerman gave that evidence, and really, once again, I would have thought that I would have remembered that. I consulted some of my old colleagues, Dr. Bukau, Susan Bukau, that also worked at the PCLU, and I also worked with Advocate McAdam. I remember Dr. Bukau being the junior to Advocate Ackerman in court, and I know that Advocate McAdam, he's drawn up charge 2, the conspiracy charge in the plea and sentence agreement. Yeah, no, I have no recollection that I was involved with the plea and the sentence agreement. And yes, I would have felt that they're not disclosing enough. And I worked on the poison list for very long, so I would have known if more targets were to come out there. So I would have thought that I would have remembered something like that. I have got no memory of being involved. And if you read the press declaration by General van der Merwe and Vlok, they also thank Advocate Ackerman for being billig and fair. They thank him for his role that he played, and he also signed the plea agreement. So my short answer, I've got no recollection being involved in the plea and the sentence agreement.
Thank you, and thanks for the additional information. Would I be correct in saying that one of the reasons you rejected the application of the first 3 for a decision not to prosecute under the guidelines was because they were not disclosing information about the hit lists and the like?
Yes, Commissioners, I never really worked with a hit list. I heard evidence about a hit list, and I know Henry van der Westhuizen worked at Trevitz, teenrevolutionaire teikenwerkgroep. I never worked with that. I worked with this poison list, the verkoperlys. So I never worked with a hit list. I had the poison list, the verkoper, the poison list, and I worked from that. So I don't really know anything about the hit list. But in any case, it is clear from that poison list that a number of more poisons was handed out to the operators. And I would like to know those targets, and I never felt they played open cards about that. And it's my feeling up till today.
And in the information disclosed by Smith, Otto, and van Staden, did they talk about the role of their superiors?
I never worked with them where they disclosed that. When I worked in the Wouterbason matter, they refused to work with me, so I had photographs of them that I showed the witnesses, and the witnesses identified them from their police files photographs. So Chris Gert and Mani never really cooperated with me. So yes, I work with Dr. Neil Barnett. I try to get evidence from Dr. Neil Barnett in the Wouterbason matter. But Chris Gert and Mani never cooperated with me.
And the first 3 suspects in the Chakani matter, Smith, Otto, and van Staden, are you talking about them?
I'm talking about them, Commissioners.
Okay. Thanks, thanks. That's useful to know. Let's move to the next topic, Mr. Pretorius. It's further down that page, 7. It's titled "The Reopening of the Timal Agate and Haffajee Inquest." And we are already on record thanking you for your constructive role in all those 3 inquests. We do have a few questions arising. You stated that you played a role in guiding Captain Ben Nell in procuring the statement of former detainee Salim Essop in the investigations leading to the Timol inquest. Do you accept that it was the family investigator Frank Dutton who tracked down Mr. Esop and together with the family legal team who prepared at least the first draft of the affidavit?
Commissioners, I totally accept that. I accept both parts. I actually have an email from you which you sent to me and say, I tried calling you on Friday and sent you a text message. I'm taking an affidavit from Salim Esop, whose evidence will be important in the Timor matter. He is here until Friday. Do you wish to see him before he returns to the UK? So yes, I confirmed. Commissioners.
And thank you for doing that research and coming up. I completely forgotten that communication. And do you also accept that those inquests ultimately happened because the families had been pushing and pressing and in fact had issued letters of demand against the NPA and Minister of Justice? The letters are set out in footnote 27 and they're in the bundle.
Yes, Commissioners, I do accept that it was the pushing of the families and the letters putting us on terms, etc. It did play a big role. I'm not totally sure about the Hafuji matter. I'll tell you why I'm not sure about the Hafuji matter, because Advocate Shabnam Singh did a lot of that of her own initiative in her own regard. But in all the other matters, it's quite true. The families have pushed that to it. So I agree with that, Commissioners.
Yes, I think in relation to Hafuji, at that point it was more a question of pushing the minister to make a final decision as opposed to the NPA, so you could be correct on that. Now, given that you were at the PCLU throughout this entire period and you were Special Director of the PCLU between 2015 and 2019. Can you explain to the Commission why the Nokuthula Simelane case, the indictment was issued in 2016, and the Timor matter, which was reopened in 2017, at least the inquest, why those were the only matters enrolled during your term as head of the PCLU?
Yes, the first point I wish to stress, Commissioners, is that I was never really involved in the Nokuthula Simelane matter. That matter was handled mostly by Advocate McAdam, and later on it was handled, Commissioners, by Sean Abrams. He gave that one to Raymond Matenjwa, Advocate Raymond Matenjwa, and they worked this. So I never really worked on the Nokuthula Simelane matter. The reason why there's only two for that whole period, we go back to what I said, that according to the information and the evidence I knew about, there was political interference, but there was also, for me, no political will in this regard. And these are very difficult cases. Cases of this state-sponsored violence, and there's a conspiracy to silence. It's not easy cases. So in that regard, these cases were not ready. That's why there was only two for that period. That's my short answer for that, Commissioners.
And perhaps that also answers the next question, because we go back a little further in time at paragraph 25. And yeah, it's again a difficult question that we have to pose. But between the Chakani plea and sentence agreement in August 2007 and the indictment issued in the Simelane case in February 2016, so that's a period of some 8 years and 7 months, no TRC matter was enrolled for prosecution or inquest. And so we have to ask you, what explains this lack of action? If it's simply what you said previously, then you don't necessarily have to repeat yourself.
Yeah, I don't want to harp on it. We've already referred to the political interference matter, but when we did the Eugene de Kock trial, when we investigated Vlakplaas, there was also a very big investigation into the Pretoria security branch. They worked with people like Joe Mamasela, and big dockets were built up against the Pretoria security branch. Similar to the Johannesburg group, the Kutsia Pretoria's group in Johannesburg. Cape Town, there was a lot of cases against the people there. Those big prosecutions never materialized because the people was pushed towards the TRC. In the Pretoria matter, when Jan de Oliveira and Antoinette de Jager of that commissioners, when they wanted to arrest these guys, they ran to the TRC and they were provided with witness protection. So those big other prosecutions did not materialize. You kind of went into a new phase where all the people that felt, commissioners, that they're going to be prosecuted, they asked for amnesty. So that gravitated them towards the TRC. So big prosecutions was not possible in those cases. Then a new approach is needed. You've got to see if there's a general that did not apply or that kind of thing. So the political interference coupled with the political will, coupled with the inherent difficulty of these cases, is all a reason why it's not easy, why these cases come on so easily. And that explains that time period, commissioners.
And if we can just pause on the Nokuthula Simelane case, you've already pointed to the application that was brought by the family in the High Court in 2015, that they sought an order compelling the SAPS to finalize their investigation and an order compelling the NPA to either take a prosecutorial decision or hold an inquest. Do you accept that it was this application that prompted action in that case?
Commissioners, I do accept that. I was not oblivious. There was also some reports in the media about the affidavits being done by Advocate Vusi Pikoli and Ackerman, etc. So yes, I accept that.
Let's then turn to the Craddock 4 matter. That's further down the page from paragraph 28. So the Craddock 4 families also instituted litigation, although a few years later. This was in July of 2021. And they sought certain relief, which included an order compelling the authorities to conduct an investigation into the missing Craddock 4 murder docket, and also to take a decision in the murder case itself. And Advocate McAdam, he filed an affidavit in that matter, dated 24 May 2021. The page numbers are in the footnotes if needed. Now, in that affidavit, McAdam stated that, and if you turn to the next page from paragraph 30.1, on 16 April 2013, the Office of the Acting NDPP, he was then Advocate Jibe, requested information about the Craddock 4 case. And sometimes thereafter, McAdam was requested to hand over the docket because it was called for by the Office of the Acting NDPP. McAdam said he complied with the request but could not recall who had made it. And then at some stage, which appears from the McAdam affidavit, and Chairperson, if you need the reference, it's page 218 of the bundle at paragraph 8. McAdam says that Mr. Pretorius, who was then acting as head of the PCLU, made an inquiry about the docket. No date was given, but it would have been after December 2015, in the ensuing years. And Mr. McAdam informed Mr. Pretorius that it had been uplifted from the PCLU. Do you recall that exchange with Advocate McAdam?
Yes, Commissioners, I do recall that exchange with Advocate McAdam. The explanation was that Weber and Benzel gave us, except for the Agate and the Ahmed Timol case, about 10 further cases, of which Craddock 4 was one of them. And we started having these meetings with the DPCI, with Crimes Against the State, this accountability meetings. And the Craddock 4 matter was mentioned in that group, and that's why that docket was needed. So yes, it's exactly that time frame that it happened. I haven't got direct knowledge of the correspondence between Advocate Jiba and Advocate McAdam. Obviously, if I sit in the tea room, I would heard about General Mark Hankel that failed his polygraph test and that kind, but I don't have direct knowledge and I don't want to speculate.
Okay, then I'm not going to ask you about, who's correct, because there does seem to be a conflict between Jiba and McAdam as to whether that docket was handed over. You would have no knowledge on that.
I have no direct knowledge as to.
Noted. And also, thanks for clarifying as to when you sought the docket. That brings it, I think, to early 2018, because that's when Weber Wenzel handed over that letter and list, I believe, of 18 cases, including Craddock 4.
That's correct, Commissioner.
And lastly, on Craddock 4, are you aware of any work done on that case in that period in question between 2013 and the docket's reconstruction in 2019?
Once again, Commissioners, as I say, maybe I don't have direct knowledge, but I lived through these things. And I was aware that Captain Ben Nell worked a lot with Dr. Susan Bukau there. There was a lot of files, TRC files in our office, and Ben Nell worked quite often out of office. So I know at a certain stage Ben Nell went down to the Eastern Cape about a certain lots. So yes, I lived in that office. So sometimes I picked up that Captain Ben Nell went down to that office. But I can't give you direct evidence about what exactly was happening on the Craddock 4 matter, Commissioners. Chris McAdam was the expert on the Eastern Cape. Even during the time of the TRC, he worked on the Eastern Cape, and he worked with a guy, Jan Anton Nieuwoud. So Chris was the expert on the Eastern Cape, on Craddock and Pepco and Motherwell, and that I don't have direct personal knowledge of it.
Would it have been difficult to, if the docket was in fact missing in that period, it would have been difficult to investigate without the docket?
Yeah, Commissioner, if I have to theorize about that now, I think if there's a possibility that the Lots can be a new witness, I don't know. I really don't have enough detail to speculate about that.
Yes. Now, I don't want you to speculate, but as a prosecutor, in the absence of a docket, it would be difficult to carry out investigations.
Yes, as a general, I agree with that, Commissioner.
All right, let's turn to the next topic that's on page 11 that deals with the Rodriguez case, and we're lucky that my learned friend Ms. Morocco has already dealt with this in some detail, so that will curtail the need to go through the various passages in the judgment. But you know, it's already been put to you that in your supplementary affidavit, you confirmed on behalf of the NPA that it had been subjected to political interference. When you were asked by Ms. Morocco on the question of the interference and why the NPA had not dealt with it in its answering affidavit, and the same applied to the minister, My recollection or my note of what you responded was you did not think it was relevant. And my question to you is, but surely the interference spoke directly to the delay which was at the heart of that case?
Commissioners, yes. I tried to explain that the first affidavit that I put into the Rodriguez case, I tried to answer all the arguments by Advocate Jaap Celier for a permanent stay of prosecution, and he used 342A of the Criminal Procedure Act. The list, the points of dispute between the parties was very second there, and I could answer most of his answers there. I knew about the long delay, and I think Advocate McAdams' affidavit has already been done at that stage, but counsel didn't want to file it before he didn't consult it with Advocate McAdam. So at that stage, I felt that the list between the parties, I can answer them without a problem. Only after Mr. Imtiaz Kaji, as a respondent, brought out all these other matters about political interference, I perforce had to answer that new allegations about that. That's the reason why I used those terms, Commissioners.
Thank you. Now, it was put to you that Kaji's information about the interference was not before the court at that time, which explains why it was not dealt with in the answering affidavits. But I want to put it to you that that's not strictly speaking correct. And we have put up just extracts from the intervention application of Mr. Kaji. And we just want to hand up those extracts with the leave of the Commission. We've
Yes,
already
indeed.
distributed them to the parties.
Yes.
So let me just explain what we have. Do you have a copy of the intervention extracts?
Is this a notice of motion?
Yes, indeed. So let's start with the notice of motion. It was filed on the 6th of November 2018. That's the intervention application. Because we didn't want to consume forest, we've only printed extracts, a couple of extracts from the founding affidavit in that application. Chairperson, we will hand up the full papers for the Commission's benefit in due course. But between, if you turn to the next page, there's a heading called Suppression of the Political Cases. And from paragraph 61 through to paragraph 62.6 on page 23 of that affidavit, it sets out the alleged interference, and it puts the parties on notice that this is going to be part of the paperwork put up by Mr. Kaji. Now, the Minister subsequently filed an affidavit towards the end of the month on the 26th of November 2018, and then your affidavit is filed on the 3rd of December 2018. So that information was already before you by the time you filed your affidavit in early December of 2018. So is it not correct to say that you were aware of the allegations and could have dealt with them?
Yeah, sorry if Commissioners, if I think long. As I say, that was a difficult time for me with the chemotherapy at that specific time. The reason why Advocate McAdams' comprehensive affidavit was not filed earlier is because counsel could not consult with him. And I'm not sure whether I had this one, I 6/11/2018. I'm not sure whether I've taken notes specifically in November 2018 of this notice of motion. I'm not sure that at that stage I don't have a clear memory that I was aware that Advocate Pekoli and Ackerman's affidavits would be added to that. I really don't have a memory of that.
Chair, if I may, if my learned friend, and I do this because Mr. Salukazana was not directly involved in the timeline that we set out. What I'm trying to find out from my learned friend and the question that he's posing to the witness deposed to 2 affidavits. Is the question that by the first affidavit, you already knew that Mr. Kaji was making these allegations and you didn't respond to them? Is that the question I'm trying to understand? So that we understand for the record what the sequence is.
Yes, the question is posed because it was previously put to the witness that these allegations were not on the record. And we're simply putting it to Mr. Pretorius that they were in the record by that time.
My question, Chair, is by which time? We have to be clear.
That they were in the record by the 6th of November 2018, which preceded the filing of the answering affidavits.
Late in November.
Yeah, the one affidavit came out in late November and the other in early December.
Yes.
But I believe the witness has already answered the question and we don't intend to take this further.
Yes.
Let's move on. I'm not going to deal with the submissions that you made because my learned friend, the Minister, has already done that. I do want to ask your response to certain aspects of the judgment by the full court. I'm now paragraph 38, if that helps you, on page 13. In fact, let's jump to the nub of the matter in paragraph 39. And I just want to read to you paragraph 64 to seek your response. It reads, of course, it may well be asked, what was the NPA required to do in the face of high-level political interference? Rather than simply succumb to it, it was open and incumbent upon the NPA to have brought this interference into the open. Victims of those crimes where investigation and prosecution was being suppressed certainly had the right to know what was happening and why such cases were not being prosecuted. Society as a whole had an ongoing interest in the work of the TRC and the follow-up that the government had committed itself to. Parliament, which ultimately represents the legislative authority of the state, had a right to know why the letter and spirit of legislation that it had passed was being deliberately undermined. None of this occurred, and the NPA must accordingly accept moral and legal consequences of this most serious omission and dereliction of duty on its part. Do you agree that the NPA does have to take that responsibility?
I don't want to portray the NPA as just the victim and that there was no fault at the NPA. I don't want to portray the NPA commissioners as such. But at that stage, you must remember, initially I didn't have information, detailed information about what happened between Ackerman and Jan Wagner, or exactly the detail where Advocate Vusi Pekoli thought that there was improper interference with his discretion. I did not have that detail at the beginning start of it. The NPA really tried to talk to all the persons concerned, from the DSO to the police, to Bester, to everybody. Please provide us with investigators. So the NPA really tried commissioners to do that. My point at that stage is what I would have seen as political will, lack of political will, not so much political interference. I don't see a big team like Shabnam Singh is having now. Obviously, if there was a big team like that in 2006, 2007, the results would have been different. But how do you engender, how do you cultivate the political will? It's difficult. So I don't want to say the NPA is blameless. Obviously, with such a portfolio, with this type of cases, yes, we must take individual blame for some of the stuff. But really, the persons involved tried their best, commissioners, to get the necessary investigative capacity and try to address that. And I mean, if you dramatically said, my kingdom for an investigator, I don't know. So I don't want to say we're just the victim. So there are individual blame also on the NPA.
Thank you. Now, Mr. Pretorius, we and our colleagues all have to make submissions on the terms of reference. We've played open cards and we've set out what we're going to be submitting. And essentially, we're going to be submitting that these political interventions did have an impact and retarded the progress in the TRC cases. But we're also going to be submitting that there were individual failures by prosecutors and police officers. And we've pointed to some of those already. For example, the Craddock 4 docket going missing for a period of time. That has to be seen as a failure. We also know that the Nokutula Simalani docket went missing for a period of time as well. We've already discussed the fact that between 2007 and 2016, there were no enrollments, either prosecutions or inquests. So would it be a fair assumption that both political interventions as well as individual failures combined led to the demise of many of these TRC cases?
Yes, Commissioners, I just want to add also political will, because I make a distinction between political will and political intervention. If there's no political will, you don't get your investigators that you need. They cut off the water and light. So there may well have been individual shortcomings along the way in a portfolio of this size and over many years. But to me, the dominant and the better events cause was the combination of direct political interference and lack of political will, and therefore chronic under-resourcing. There was a genuine will to prosecutors. The resources just didn't happen. So I would just also add political will to the submissions there, Commissioners, and I think PS Pigo have given good evidence about that, Commissioners, in regard to political will. So yes, and the question is where's the greater weight lies, but to give it all to individual shortcomings would not be correct if you try to say it's just a lack of individual shortcomings. I would add these other matters.
Thank you. We can turn to the next topic, which is on page 15. And actually, I think we can truncate this because you have dealt with it already in your evidence in chief and also under cross-examination by Ms. Morocco. So the question really is, we were wanting elaboration on your claim that you didn't have direct personal evidence of political interference that in matters that you personally handled. And if I recorded your responses in your earlier evidence, you said factually I could see that cases were not going ahead in relation to the exchanges between Wagenaar and Advocate Ackerman and the subsequent and the impact of that, you said you believed Advocate Ackerman. So would I be correct in saying that during that time period, and for us the crucial time period would be between 2003 and around 2010, that you were aware of the issues facing those pursuing TRC cases in the PCLU?
Commissioners, it's correct, and that's why I referred to the speech that I did at the TRC tenure on, where I said, and from that it's clear, Commissioners, that I was aware that we were looking for investigators. Yes, I was aware.
And we have placed on record, we've referred to them in paragraphs, the subparagraphs of 44. We've made reference, for example, to NPA annual reports and Justice Portfolio Committee meetings where reference was placed, referred to the fact that the TRC cases were placed on hold. There was a failure to secure cooperation on investigations and that they would only commence after the 2010 World Cup. So we just put those up just to reinforce the fact that even outside the PCLU, it was known that these challenges were being faced. You accept that?
I accept that, Commissioners.
Were you also aware that following the plea and sentence agreement in the Chakani case that Advocate Ackerman was removed from his duties on the TRC cases?
Quite, Commissioners, I was quite aware of that.
Before I forget, my colleague has just reminded me, do you perchance have a copy of your speech that you gave at that conference on the 10th anniversary of the
Yes,
TRC?
Commissioners, we did make copies of that.
Okay, we would be grateful to receive a copy.
Mr. Vani, we do have a copy of the speech called 10 Years On, Truth and Reconciliation Commission South Africa 10 Years On. Is that the speech you are referring to, Dr. Advocate Pretorius? Advocate Pretorius, we do have a copy of your speech.
Yeah,
Is
yeah.
this the copy of the speech you are referring to?
Yes, Chairperson, that's
Thank
exact.
you.
Thank you, Commissioner.
Odd enough, my team tell me we don't have a copy, but we can secure a copy after these proceedings.
Yes.
Yeah. Thank you. And then the last issue we want to deal with is a memorandum that former NDPP Petoy sent to the former Justice Minister Lamola, dated 2nd December 2020. It's titled Briefing on the TRC Cases. The version that we've been furnished by the Department of Justice is signed by NDPP Betoy, but it doesn't have any signatures of the Minister or anyone else. Now this memo referred to historical problems plaguing the pursuit of the TRC cases. It's quite a detailed memo, but I'll just highlight two paragraphs. 2.29, the irreparable damage caused by the blocking of investigations for a period of 7 years cannot be underestimated. And then secondly, the consequences of the willful blocking of TRC investigations at a critical time and for a protected period must be accepted and responsibility taken. This is one of the greatest impediments to being able to do justice to the cases. Full documentary evidence proving the extent of the interferences in the NPA's possession. Should the Minister require, we stand ready to make a presentation to the Minister so that there's no misunderstanding of the issues and its consequences. Now, you were still in the PCLU at this time. Were you aware of this memo, and did you make any inputs into it?
Commissioners, no. In March 2019, I was relieved of my duties. So I've read this memo last night. I've also looked at the contents. It's not my wording or my approach. I think you should ask Advocate Chris McAdam. It seems to me that it is Advocate Chris McAdam that helped the NDPP Advocate Shamila Batoy in drawing up this. I didn't give any input into this.
Thank you. We certainly will ask Advocate McAdam when he appears. But now that you've read the memo, and given that it deals or tries to explain the very slow progress in the TRC cases, do you believe it's a fair representation of what happened?
Yes, it's not my words. Blocking of investigations is not totally my blocking, but whatever you call it, the moratorium, while the prosecution policy amendments is still worked in it, it's an effective moratorium that's there. So I would have used possibly other words, but I accept the gist of it, yes.
Thank you. No further questions, Chairperson.
Thank you, Mr. Vani. Any re-examination, Mr. Salugazana?
Yes, Chairperson, just 5 questions.
Sorry, Chair.
Oh, sorry.
Oh, sorry, Mr. Soni, I overlooked you. Yes, Mr.
I think
Soni?
it's the signage.
Yes.
Morning again, Dr. Pretorius.
Morning, Advocate Soni.
Good day. It's no longer morning.
As you please, Chairperson. I want to start off, Mr. Pretorius, by recognizing the tremendous work you've done in the criminal justice system. I also listened in awe to the evidence you gave today, especially your recall of particulars of matters that you were involved in and the dedication you have shown. So I just want to place that on record.
Thank you, Advocate Soni. Thank you.
Now, Doctor, I'm going to deal with a couple of matters that are raised in your affidavit, in your statement to the Commission. It appears that pages 1 to 24 of the big file in front of you. In addition to that, Doctor, I also want to refer you to a set of documents headed PCJ 1 to 14. Have you been given a copy of those? We did give it to your legal team yesterday and asked that it be made available to you.
I'm not aware of Jacobs's PJ 1 to 14, but I think it will be given to me presently, okay. Commissioner.
They are just more, I just don't want to interrupt the flow of the cross-examination.
Fine.
I don't have. We also do not have a copy of those, Advocate Soni.
Chairperson, I asked the administrative staff to make it available. I did
Yes.
that.
What we
I understand
do
it's
have
bundle 14.
bundle 14. Bundle 14.
pages, Mr. Soni?
I'll tell you
You'll
in
get
a
to
moment.
the relevant pages when you cross-examine.
Yes,
when you
I will
cross-examine.
indicate that.
Yes.
Now, Dr. Pretorius, you served on the PCLU from its inception in 2003.
That's correct, Commissioners.
And you were with the PCLU, as I understand it, until your retirement in May 2022.
Correct, Commissioners.
And you became the special director at the PCLU between October 2015 to 2019.
Correct, Commissioners.
Now, one of the things you say is that except for this period when you were the special director, you played no management role in TRC matters. And I'm just referring you to paragraph 44 of your affidavit.
I only start playing a management role in TRC matters after October 2015 when I was appointed. Before that, yeah.
Yes.
So yes,
Yes.
I believe my evidence would be that, Commissioners.
And as I understand it, that's the first time you became involved in the Timor matter.
That's correct, Commissioners.
Now, of course, I'm required to put this to you because Mr. Kaji, and it is the statement that brought you to the Commission, made certain allegations relating to the investigations, the initial investigations in the Timor matter.
That's correct, Commissioners.
Now, what he says is that there was no concerted and intentional will at the PCLU to investigate the death of Mr. Ahmed Timor. That's his allegation. I'm just placing that before you. And it is to that you respond. Am I correct?
And that's correct, Commissioners.
And your response is at paragraphs 20 to 24 of your affidavit in regard to that allegation. And then he and my learned friends, but especially Ms. Morocco, raised with you... Morocco. Sorry. My learned friend raised with you the issue of the political interference which was first raised by Mr. Kaj in the Rodriguez application to stay matter.
Yeah, we've got to define first raised, Commissioners. Obviously, when Advocate Piccoli and Advocate Ackerman put in their affidavits in Kadimeng, Nokutola Simelane matter, it would have been raised there.
Yes,
obviously,
I'm saying
we would
in the Rodriguez matter.
in the Rodriguez matter, yes, Commissioners. I agree with that.
And my learned friend, Ms. Moroka, went through the sequence of events. There was the applicant's affidavit, your answering affidavit, Mr. Kaji's answering affidavit, and then your supplementary affidavit to that.
That's how I remember it, Commissioners.
Yes. Now, in paragraph 49, in reference to both these allegations, you say that in relation to the Kaji matter, paragraph 47, you say in relation to the Kaji matter, I reviewed the docket and provided leads, conducted research and consulted with Mr. Chris McAdam and others. Then you say, I prepared a memorandum to the Minister of Justice through the NDPP recommending that the inquest be reopened. Do you have a copy of the memorandum?
Not with me. When I went on pension, I didn't take a lot of documents with me, Commissioners. But I really think that that one can be found if we are looking for it. If I go to the NPA offices, Commissioners, I really think, and we will be able to find that. I don't have that in my possession, but at the document center at the NPA, it would not be impossible to find that memorandum.
Would you be so kind as to ascertain if you can find it?
By all means, Commissioners. I'll
Chairperson, I don't wish to interrupt, but it might be helpful to Mr. Sony to point out that it is part of the cross-examination bundle. It's item 23 at pages 341 to 347. And those were the documents, it was part of the documents that the Department
On
of Justice
page?
put up. On page. I've been corrected. It's not part of this cross-examination bundle, but it is part of the DOJ bundle and was used in respect of the current minister's evidence. So it's in the DOJ bundle at page 341 to 347. It's in the bundle titled Documents Received from the DOJ on 23 and 30 July 2026.
Yes, Mr. Soni?
Yes, sorry, Chairperson, I was not aware because we looked at the documents
Yes.
that are contained here. But we will look at it and we will refer to it perhaps at the appropriate time.
Yes.
I just want to ask you, Doctor, in paragraph 9, I think it is, of your affidavit, you say that you prepared a memorandum. Is that the same memorandum you're talking about?
I believe so. I haven't seen the memorandum now, but I believe it would be the same.
Okay. Now, in your memo, I take it you would have gone through all the documents that were sent to you in regard to the Timol matter in 2015, when you first dealt with the Timol matter.
Yeah, just a small correction, Commissioners. I only started in January 2016.
Oh,
2015, I was still quite busy with Marikana and SARS investigative units and other matters. So in January 2016, I started. But yes, the answer remained the same. What I could get from Advocate McAdam, because McAdam worked on this before me, and what I could get from Ben Nell, Captain Ben Nell, all those things would have been gone through, plus the book of George Bezos and a lot of other things I went through. Yes, I went through all the documents.
And would you have also had the TRC record of Mr. Timol's mother's evidence at the TRC?
Commissioners, I don't have a total independent recollection, but I think obviously I've read Imtiaz Kaji's books, the books that he has written. I would have read those books also, and somewhere there I would have seen, somewhere I deduct that I would have seen that evidence in either the books or the documents that were provided to me, yes?
Right. Now, can I ask you to please turn to PCJ 5, which appears at 1723. particular would like you to look at page 1725.
Okay, I'm at 1723, Commissioners. I'm on 1725 now.
Okay. I just say to you, and just to put this in context, in this memorandum which was prepared by Advocate Ackerman, he was giving an audit of the cases that the TRC had been dealing with. And he divided the cases into different categories. The first category, which appears at page 1725, is at paragraph 2, and you'll see the heading to that is cases finalized in court, and he lists 4 cases there. Do you see that?
Correct, Commissioners?
All right. Now, can I ask you, have you seen this memo before?
Yes, I think it's part of the Colata group of papers. Yeah, I'm quite sure it's part of the
Well,
Colata.
it certainly is Mr. Jacobs's.
Yes, but I've seen it before. Matters closed by the PCLU.
Okay.
So I think I've seen this before. I'm quite sure that it's part of the papers of the Colata group. This specific memo done by Ackerman, you say?
Did you have a role in this memo?
No, not at all.
Now, you'll see in,
A commissioner.
sorry, at the time this memo was done, which is October 2006, were you aware that the Timol matter was being referred to in this memo?
Not specifically, Commissioners. I was not specifically aware that it was referred to.
Let me then read to you what it says. You'll see it says matters closed by the PCLU, and it says that in detention of Ahmed Timol, and 3.1.1 says this matter relates to the death of Ahmed Timol, who died in police detention on the 27th of October 1971 during interrogation by the apartheid security police. Then 3.1.2 says there was an allegation that one of the interrogators had confessed to a journalist that Timol had been murdered, and that this was followed up but was later denied by the said journalist. And 3.1.3 says the matter is therefore closed. That's what that is what this memo or audit records on the Timol matter and why it was closed. You accept that?
I accept that, Commissioners.
And just for continuity, I want to read to you 3.2, which deals with the death in detention of Steve Biko, and this says, the matter prescribed in 1997 as evidence only proves culpable homicide, which according to our criminal law prescribes after 20 years. That's the reference to Steve Biko.
I see that, Commissioner.
Can I ask you then to please turn to page 1737. You'll see that that is a memo dated 30th of October, and in regard to TRC cases that are closed, it refers at 2.1 to the death in detention of Ahmed Timol, and in 2.2 it deals with the death in detention of Steve Biko. Can I, before I read to you what I want to point out to you, this memo, you'll see right on the top of, at paragraph 1, says that in regard to the memo of the 25th of October, the PCLU was required to provide more details, and so this just gives more details to the matters that I referred to earlier.
I follow, Commissioner.
And it says, again, in regard to Mr. Timor, the debt in detention, this debt in detention matter goes back to 1971. 2.1.2, the nephew of the deceased requested that an allegation that one of the police officers who had interrogated the deceased had confessed to a journalist be investigated. The DSO traced and interviewed the journalist who denied the allegation. There was no other evidence to prove that the deceased had definitely been murdered and all other crimes had prescribed. 2.1.4, the matter was therefore closed.
I see that, Commissioner.
Now, can I ask you, at the time you did your memo in 2016 in relation to the Timor matter, the opening of the inquest and so on, were you aware that these events had taken place, that this was what the decision of the PCLU was in regard to the Timor matter?
Commissioners, yes, I would have consulted with Advocate Chris McAdam, and Advocate Chris McAdam did give evidence of how he instructed Andrew Leask to, while he's down in the Cape, to talk to people. So in an indirect fashion, I would have known that Chris McAdam has followed up on that, and there was a negative answer that came through. So indirectly, I was aware of some, but I can't say I specifically remember that the matters was closed. It's like the Smith murders. I told you that the Smith murders was also closed by PCLU management on a couple of occasions.
Yes. So in regard to the Smith murders, can I ask you to please turn to page 1729? And you'll see there in regard to that, it's at 3.2.1. Perpetrators all deceased except one suspect who apparently lives in Australia. Insufficient, 3.22.2, insufficient evidence to apply for extradition. And in 3.22.3, matter closed. And you'll see, Dr. Pretorius, it is you who took that decision based on what he set out in this memo.
No, Commissioners, it's the case was allocated to me, but it wasn't me that took the decision to close the matter. It wasn't me that...
I'm sorry, I apologize.
It wasn't me that... no. So it was allocated to me, yes, and I worked on it, and I don't think this was the first time that the matter was closed. I think there's another memorandum that also referred to the Smith murders that was closed. So no, it's not me that took the decision that the matter was closed. I think I referred that the management style is getting things done, and they set priorities, but it's not me that closed the matter.
Who took the decision?
I would say that I think it's Advocate Ackerman. I say I don't have hard evidence, but I would say it was Advocate Ackerman that decided. His style is, let's set priorities. If you do a charge sheet against Eugene de Kock, he'll give you a cut-off date and say, all the charges you want to put against Wouter Basson or Eugene de Kock, this is the date, and then it must be done. So his approach was getting things done, and he would have set priorities and said, no, there's no possibility that somebody in this case is going to be prosecuted. So the matter is closed.
And in regard to the Timor and Biko matters?
I think it would also be Advocate Ackerman.
Okay. And one must accept this being a document, by the way, which was prepared for Dr. Ramaite, who I think was the deputy NDPP at the time, and it was to be presented to the interdepartmental task team that the document would reflect correctly what the reasons for the different decisions were.
One would suspect that much, Commissioners.
Now, if one looks purely at what is contained in regard to the Timol matter in the two audits that I've read to you, you will see there that there is no indication that there was a problem with the investigators. In fact, the DSO had investigated the matter.
I agree, Commissioners.
And in regard to this matter, I'm talking specifically about the Timol matter. There is no indication that there was pressure from above. It's made on the basis, as you say, Advocate Ackerman's stance was, look, let's prioritize and let's get these things done. If we can close the file, we'll close the file and concentrate on those matters that will produce results.
Commissioners, I think that's a fair summary.
So I'm just saying, and I'm going by the matters that were raised in the Rodriguez application. So that, as has already been pointed out today, was raised on the basis that Mr. Rodriguez said that there had been an undue delay, he'd been prejudiced, and he seeks a permanent stay of prosecution. That's the thrust of his application.
I hear what you say.
Do you have...
No, I agree with that. That's, we can quibble a little bit exactly, did they use 342A or did they use Section 35 of the Constitution or whatever, but in essence what you said, that's correct.
Okay. Now, you, in your first affidavit, you set out why the matters that Mr. Rodriguez raised do not constitute a basis for such an order, the order that he sought. I mean, you said you were not at fault, Rodriguez was at fault because of all these years he appeared to deny various things and so on, and therefore a case had not been made out for a stay of prosecution in that matter.
Commissioners, we must make a distinction here by when was the decision to prosecute taken in that case. The decision to prosecute, I could answer all the allegations by Advocate Jaap Salier by saying once a decision to prosecute was taken, it took a mere 8 months before this case was in our High Court. So I could answer all that.
Yes.
The delay before this decision to prosecute was not taken into consideration at that stage. Commissioners.
As was pointed out to you earlier, your answering affidavit, that's the first affidavit you made, didn't refer to political interference.
Quite true, Commissioners.
When Mr. Kaji made, or asked to intervene and made his allegations in his affidavit, you then, in response to that, said that it is so that there was political interference, and you raised resource constraints as well.
Correct, Commissioners?
Yes. Now, whatever the position is in regard to other matters, I want to put this to you, Dr. Pretorius, that was not the reason the matters were, the Timol matter was closed in 2006, as appears from here.
It's correct, Commissioner.
Now, I'm not casting aspersion, I'm just saying on the information before us, we can say certainly in regard to the Timol matter, the first decision in the Timol matter, it had nothing to do with resource constraints, lack of investigators, and so on.
I agree, Commissioner.
Now, can I then ask you on an entirely different issue?
Mr. Soni,
Yes, ma'am.
I see it's past lunchtime. How long are you going to be in your cross-examination?
I don't think I'll be more than 5 to 10 minutes, Chair.
Okay, we can proceed.
I'm quite certain
Thank you.
that we won't starve between now and the time I finish.
Okay, yes.
Chairperson, before we proceed, we are constrained to point out that an incorrect proposition was made to this witness in relation to the DSO investigating the Timol matter. And with your leave, we would like to place the actual evidence on record.
Yes, yes, you may.
Chairperson, was put to the witness that the memo that Mr. Soni referred to, he put it to the witness that there was no indication that there was a problem and that the DSO had investigated this matter and there was no pressure from above. The actual evidence is reflected in the affidavit of Advocate McAdam, and that's in some places. For example, it's in Bundle 1 at page 294. It's also in Bundle 8 at page 284. I want to read into the record paragraph 44. And this is the...
Chairperson, I must object to this.
Yes,
I was very clear, Chairperson, that I was referring to the decisions taken in 2006 as set out by somebody from the PCLU, but most probably Mr. Ackerman, as to why this investigation was closed. And what is indicated in regard to the second memo is that the allegation had been made about a journalist. The DSO had seen the journalist. The journalist didn't confirm the allegation, and it was therefore that the matter was closed. Now, whatever Mr. McAdam says afterwards is irrelevant to what happened at this time.
yes. Mr. Vani?
Well, with respect, Chairperson, it's not irrelevant because the suggestion was put to the witness that the DSO had investigated this matter. And in fact, Mr. McAdam in his affidavit says that the DSO advised him, in fact, Andrew Leask advised him that the DSO could not investigate the matter. And what happens, and as reflected in paragraph 44 of the McAdam affidavit, is that Leask advises McAdam that because of a decision made, the DSO will not investigate TRC cases. But he says, as a favor, he is heading to Cape Town and he will check with the journalist, and that is the extent of what happened.
Yes. Mr. Soni?
Chairperson, the document speaks for itself. Whatever Mr. McAdam wants to qualify afterwards, what is set out here sets out why the decision was taken to close this matter.
Yes.
It is set out, it says 2.1.3. So the nephew, 2.1.2, that's Mr. Kaji, presses the PCLU to deal with the matter. 2.1.3, is recorded. The DSO traced and interviewed the journalist who denied the investigation, the allegation. There was no other evidence to prove that the deceased had definitely been murdered. That's what's recorded. We can only go by that, Chairperson. Whatever is said, Mr. McAdam will come and testify about that. But that's specifically why I asked the witness who had prepared these matters, these documents, because they record contemporaneously what was going on at that time. That's all we can go by. We can't thereafter revisit something with hindsight and say, well, I should have said this and should have said that.
Yes.
And I specifically said, Chairperson, that at the time these memos were prepared in 2006, the witness, the position was that the decision was taken for the reasons set out here.
Yes. Mr. Vani?
We won't take this any further.
Yes. I think I will allow Mr. Soni to continue with his cross-examination.
I'm indebted, Chairperson. Now, at page 34 of your affidavit, paragraph 34 of your affidavit. Sorry, Chairperson, I since you I seem to have got my pages mixed up. But, Mr. Dr. Pretorius, may I ask you this? In your affidavit, in your affidavit in the High Court matter, not affidavit here, in the Rodriguez matter, you say that it was Mr. Kaji who asked for this matter to continue. You recall that? Well, perhaps I should just...
Yeah, maybe if I can answer it that way. From the beginning, Mr. Kaji was involved, and the court even thanked him for the role he played. So, yes, it comes down to that. So, the court even thanked him and said the other people should follow his role.
That is so. And what the court also said is that it was the family which ensured that this matter was reopened, and that was all done in the public interest. And as you say, they were model citizens in regard to constitutional rights.
I confirm that, Commissioner.
Now, in regard to the Chikane matter, which I want to come to next, in regard to the Chikane matter, if you turn to page 170 of the file in front of you.
Just repeat the page, please.
170. Part of this has been raised with you by my learned friend, Mr. Varney, but you see from paragraph 10, line 10 of page 170, and this is the evidence of Mr. Ackerman in relation to the plea and sentence agreement in the Chikane matter. He says, I was not a party to the negotiations regarding the plea and sentence agreement. Nobody has disputed that. You, as I understand it, say you were not involved in the negotiations.
Yeah, I've got no memory that I was involved, and I said I would have think that I would have known, and I referred to the plea agreement itself with his signature on it, and the press release, yes.
Do you know who would have been involved? Or who was involved?
I would have thought it is Advocate Ackerman because the name appeared, it's his signature. I really would have thought it's him. I know he objected to the constitutionality of the new policy, but thanks to the family that thanked him for his fair and role that he played in there, I would have thought it would have been Advocate Ackerman, and he was handling this matter.
Yes. And you say the fair role he played, that was a statement, I think, issued by Mr. Flock and Mr. van der Merwe after the matter was finalized in court.
That's correct, Commissioners.
And then, but he Mr. Ackerman continues, there was a separate committee formed. I think it was under Dr. Pretorius. Now, I accept that you say you can't recall. And they were 3 or 4, and they completed this. Are you aware of such a committee?
Commissioners, really, I'm not aware of such a separate group that would have worked on this. I'm really not aware of it.
Okay. Now, do you know, would you have come across in the work you did with the PCLU Colonel Bester, who was one of the investigators?
Yes, no, I know. He referred to us, yes. I know Colonel Bester, Commissioners, and he also, he gave evidence in that, no Colonel Bester. He's been on pension for some time now.
So I just want to put to you, relating to the allegation about lack of investigators. It was a matter that he addressed because the allegation had been made. And this is what Chairperson Colonel Bester gave evidence earlier this week. And his evidence starts at his affidavit starts at page 1 of this week's bundle. And I just want to read one paragraph to the witness.
On Monday.
From
his
Monday.
Evidence was on Monday.
That is so, Charles. He says, I wish to inform the Commission that owing to my other investigative duties related to weapons of mass destruction, nuclear, and 2010 World Cup events, I interacted with members of the PCLU, including Advocates Ackerman and McAdam, frequently. Would he have interacted with you as well, Doctor?
Yes, he interacted with me as well, and he gave evidence like that.
Yes.
He did
yes.
give it. Yes, he interacted with me too, yes, quite.
But this is what I'd like to put to you. This is what he says. As far as I can recall, we never engaged in discussions involving the difficulties experienced with the investigation of TRC-related matters. I also work closely with Advocate McAdam in many matters and enjoyed a good relationship with him. Now, can I ask you, would you have raised the difficulties encountered with securing investigators with him?
I'm thinking about the question, Commissioners. It was not my portfolio, so I didn't directly work with it. And he gave Captain Ben Nel, Ali Masigela, and Joe Makua was the investigators that he did provide in that regard. My only remark that I can say is if we compare that now with Advocate Singh's outfit, or if we compare that with Jan de Oliveira's outfit, obviously we would have seen that it's much bigger, at least 15 investigators, 4 prosecutors, etc. like that. It was not my portfolio. If I experienced problems, yes, I think I would have raised it with him.
Yes. Can I just ask you in relation to what I think must be accepted by this commission and by any reasonable person. there has been an unacceptable delay in the investigation and prosecution of TRC cases. Just given the sensitivity that those must prompt in all of us, having regard to our history and transition in 1994.
Commissioners, I agree.
Now, when you were asked about the possible factors, this is what you said, and tell me if I'm correct, if I've recorded you correctly. You say, yes, there were individual failures, talking about perhaps police or prosecutors or whatever it is. And then there was political interference, but there was also a lack of political will.
It's a good summary of mine. I would just also add the inherent problems in investigating these matters.
Absolutely.
That's the other one that I would add, but further it's a fair summary.
You've reminded me of an issue you had raised earlier in your evidence. And can I also then say that it seems as if the investigation and prosecution of these matters have turned the corner from the time that further resources were brought about the time you headed the PCLU.
I agree with that. Thank you, Commissioner. I agree.
Chairperson, those are all.
Thank you.
Dr. Pretorius, thank you for your evidence. I just want to ask you in relation to the last document put to you, the evidence of Colonel Bester?
Yes.
Yes. Had the DPCI been established by then? This was in 2010.
Commissioner Gabriel, I think, yes, it has been established at that stage.
Right. So at that stage, there wasn't a problem with investigators.
I'm thinking before I give an answer to say there wasn't a problem with investigators. Obviously, the priority was the World Cup. So of the 15 people that later assisted me when we had meetings with Weber and Wenzel and Advocate Varney, of that 15, number of them would have been involved in others like nuclear matters or that kind of thing. So I'm wary to say that there was absolutely no problem with investigators.
Okay. Earlier on in your evidence, you said that, I take it now, this is the period prior to 2010. There was a lack of political will, there was no investigators, and you spoke of problems with the DSO. So,
correct, Commissioner.
right. So when you were asked about what your assessment of the problems were, you gave 3 reasons as I understood them. Direct political interference, of which you accept you had no direct knowledge. A lack of political will and a chronic lack of resources. Now, what do you mean by a lack of political will?
Commissioner Gabriel, if there was a political will, like there's a political know of Advocate Shaplan Singh outfit, etc., the people that would be, it can be civil society also, but the politicians would have appointed a new Jan de Oliveira investigation team with 15 investigators and 4 or 5 prosecutors. So if there was a political will, the resources would have followed that. And they wouldn't have said, no, we wait 4 years, we're first going to do prosecution policy, etc. If there was a political will, we would have seen a different situation at that stage.
And then you speak of a chronic lack of resources. Now, what was that?
The resources is the investigative resources. Firstly, also sometimes you need experts. If somebody fall from a building, obviously you need an expert to come and analyze that kind of thing. So that kind of resources must be provided to you, Commissioner. So yeah, you need that kind of resources very early on, or a doctor that can look into the post-mortem and say, oh, this post-mortem is not correct, you must reopen this. So you need that kind of resources. But mostly investigative. I would say mostly investigative resources.
Thanks. Then the next issue I want to raise with you is the affidavit of Ackerman and Vusi Piccoli. Let's just focus on the affidavit of Vusi Piccoli, which was first put up in Nkadimeng 2. Am I correct?
Correct, Commissioner.
And that was before the Rodriguez matter.
Correct.
Now, you spoke of media, that this was in the media. Were you aware of the contents of Piccoli's affidavit before Rodriguez?
Commissioner, not really.
Not
Obviously,
really, that's fine.
I was not really the detail as to how we tried to work this thing, and then he felt at his wit's end, etc. I didn't have the detail of that. I've taken note in the media that Advocate Ackerman and Piccoli said there's political interference, but that's just my general perception at that stage. And I was not involved with that case
At that time. Okay. Then, just in your statement that you placed before this commission, can I take you to paragraph 52.1? Do you have it?
I'm not having it,
This is-
but if you can just, I'll try to follow if you want to. If you don't
Okay,
mind.
so
I think it would be quickest.
Let's start with 52. You say, I do not have direct personal evidence of political interference in any matter that I personally handled. So in the TRC matters that you handled, is that correct?
That's correct, Commissioner.
And you say, where I refer to political interference in relation to TRC matters, I do so on the sworn versions of those who did, including advocates Piccoli, Ackerman, and McAdam.
That's correct. They were at the coalface, Commissioner. They worked with the Justice
Right, so they were at the coalface.
Yeah, I was not.
Right. Then in 52.1, you say, I refer to the contents of and align myself with the affidavit of Advocate Vusi Piccoli, deposed to on 6 May 2015. Now, my question is, why do you, before this commission, align yourself with Vusi Piccoli's affidavit?
Commissioner, because I like his nuanced approach. These things is difficult to manage. These cases is difficult to manage. I've been criticized about the letter that I've written in the Pierre Steyn inquiry to the then president. And I really think Advocate Piccoli tried to get this new prosecution policy to work till he saw, no, this is not the interference that I agree with. This is not correct. So he initially tried really to make it work and get this new thing going. And I like that approach. I support that. I understand it.
So what Advocate Piccoli said about him being impossible to focus on his TRC work, do you align yourself with that, given that you have no direct knowledge of such matters?
Can you just, I'm just trying to comprehend exactly what you're asking of me, Commissioner.
So in his affidavit, if my memory serves me correctly, Mr. Piccoli went to lengths to say that there was political interference in his work on the TRC cases as the head at that time. Now, I'm trying to understand why before this commission, you say in your statement, I refer to the contents of and align myself with the affidavit of Advocate Vusi Piccoli. Now, are you aligning yourself with the allegations that he made of, let's say, political interference in the progress of the TRC cases?
Yes, I do.
Why do you do so?
Firstly, because I know the man, and he was the one that came to the PCLU and ensured that we got some resources, etc. And also, after reading his statement, I really saw that he tried to, as a DG coming over, trying to work and get the management of these difficult cases to work. And then he said, no, this is improper. Now you're infringing on my prosecutor discretion. So yes, and yeah, that's why I thought that I can align myself with his version, where he said I tried to bring this in and manage this correctly, and then I saw this improper interference. That's why I aligned myself.
And in response to questioning earlier today, you said you lived through these times. I know it's a difficult question to answer, but what did you mean that you lived through these times?
Previous witness commissioner Leesk referred also to the matter that you would come into the tea room and Ackerman would say, they falsified my handwriting. So he would say, they falsified it. So you see that, you don't know the full context of why they falsified and what they want to achieve through it. So yes, I saw Ackerman when he was livid about, he said they falsified his handwriting. So, and I saw that there was no investigators, and that's why I dramatically said, my kingdom. So yes, I lived through it.
And that's, you're referring to your speech?
Yeah.
Okay, thank you very much.
Thank you, Commissioner.
Chair, if I can just request this, not to Mr. Vani, not as part of an objection, but there is a juxtaposition that you were going to refer to. I would, for my part, want to, without comment, to read what you were going to read, so that in the end, the Commission can take into account what you were going to read. Without comment, and unless the chair says so, the witness, Dr. Pretorius, need not answer to it, but just for the record.
Yes, certainly, Chairperson. To be clear, are you referring to the extract from the Macadam affidavit that I was going to read?
Yes.
Okay.
Yes.
So as mentioned, it's paragraph 44. It reads as following. At the time of deposing to this affidavit, I was not in possession of Annexure RCM1. At this stage, when I have now had sight of both this document and RCM9, I recall that RCM9 was written after both the DSO and SAPS had refused to investigate TRC cases. If memory serves me correct, Leesk had informed me that as a result of the decision taken by Ledwaba that the DSO would not investigate TRC cases, he was unable to comply with my original request for investigations. Since he was, however, traveling to Cape Town on other investigations, he contacted Ivor Powell and questioned him regarding the confession apparently made by the applicant in this matter. The allegation was, however, denied by Powell, and Mr. Kaji was informed accordingly. I did not hear anything further from Mr. Kaji and was shortly thereafter assigned other work.
Yes, thank you. Thank you, Chair.
Thank you.
Yeah.
Sorry, one more question for you, Dr. Pretorius. You know, we've been given your speech, but I don't think it's been formally placed on record. It's entitled Truth and Reconciliation in South Africa, 10 years on. And I think it's important to have this on the record, and tell me if I'm stating what you said. In page 23, the last paragraph says this: so prosecutors are ready to proceed. This is now you speaking 10 years after the TRC report, presumably. But a prosecutor cannot do this alone. There are a number of obstacles, I want to say my kingdom for a good investigator. An investigator that has the will, not the political will, but the will to investigate these matters and see them through. Even more important, though, is the need for independent investigators. South African Police Services still has to appoint investigators for the matters that have been identified by the prosecution. For us now, however, it would be premature to pronounce on how the National Director of Public Prosecutions will use his prosecutorial discretion. So, if I summarize correctly what was in your speech, you're complaining that 10 years after the TRC, you're still lamenting the fact that there are no investigators, or proper investigators.
It's
Have
correct.
I got that correct?
You've got that correct. Thank you.
Thank you so much.
Dr. Pretorius, when you allude to the fact that there was no political will to investigate, where did that political will emanate from in your view? Is it from the NPA or outside the NPA?
Chairperson, I'm thinking if it encompasses both. It's a combined approach. Political will, it's not just a willy concept if we talk about the political will, but the powers that be ensure that you get the necessary investigators and you ensure that you get the necessary experts, etc. So it's not just the NDPP, but it must also be the minister. So for me, political will is more than just the one or the other. It's the management of the whole thing. So I would say the political will is both from the government side as well as from the people, the leadership of the NPA itself.
So as we know, the minister is the one who is responsible for the administration of the NPA. So in this case, you would say it's the minister.
Not just the minister, more than the minister. Also the people at the NPA, where there was a lot of new NDPPs coming and going, etc. So that instability also has an effect on it. So I would say it's not just the executive or the minister, it also entails the leadership of the NPA itself, Chairperson.
Thank you.
Now, we know that the Constitution provides 4 SAPs to investigate crimes in our country. It's been your evidence that there was a lack of political will, there were no investigators. Who would be responsible at a political level for the provision of such investigators, or at an operational level?
Yes, Commissioner, obviously, according to the Constitution, it is the police, it's SAPS, it is the police, that kind of thing. But you see my approach working through Goldstone and all that, civil society also plays a role.
I see.
The civil society is also important for me. Judge Goldstone could get the results that he got because he had civil society at his back. There was a lot of leadership, etc., that ensured that the necessary witness protection is given, or that witnesses can be protected overseas, etc. So political will to me is more than just the executive of just SAPS. It's a will that also originates from civil society to get these things going.
And when you gave your famous lines, my kingdom, for an investigator, who would have been responsible for the provision of those investigators?
I would have hoped that civil society would go and talk to the Minister of Justice or the Minister of Police and say, hey, we can't have this.
Okay, thank you.
Mr. Salukazana?
Thank you, Chairperson. Mr. Pretorius, or Dr. Pretorius, I only have 4 questions for you. Perhaps to start with Mr. Soni's, or at least the colloquy between you and him, you were referred to PCJ 3, and it's a memo dated 25 October, and it speaks about the closing of the Timor investigation. Do you remember that? The memo Mr. Soni referred you to.
Yes, I remember that when I was
Certainly.
asked about that, Commissioners.
And then when did you become involved in TRC matters at the PCLU?
I became involved in January 2016 when I was at the meeting with the NDPP and Weber and Wenzel and Advocate Varney, etc. I became involved, but I was also not oblivious of those matters. In the meantime, I still worked on the Smith murders, and I could see there was no investigators, etc. So it wasn't a watertight isolation. I was aware that there's TRC matters, and I wasn't oblivious to those.
And then when you got involved, did you do anything about the Timor matter?
Oh, yes, yeah, obviously. That's what I tried to set out in my affidavit, yes.
Certainly. What did you do?
Well, I immediately used my contacts to see if I can't get some witnesses like the Stratcom guy or Val de Toey. I talked to my contacts in the police to see if they don't know anything about that thing, and I consulted with witnesses that I knew worked at John Foster and that kind of thing. So I immediately started working and worked very well with Weber and Wenzel and Advocate Varney especially.
And you did this despite the memo saying the matter was closed?
Oh yeah, I mean the Smith murders was also closed a couple of times.
So under your leadership, the Timor matter was reopened, and it ultimately resulted in an inquest.
Yeah, well, it was a request from these people. Obviously, they went to the NDPP and asked for a reopening. So yes, from there, pushing, I did reopen it. I thought, after I've seen Dr. Aesop's affidavit, I thought, yes, it's clear to me that justice was not done.
Thank you. And then during Mr. Vani's cross-examination, you were referred to a statement that only 4 matters were enrolled or led to inquests. Under your leadership, do you know how many matters were enrolled or that resulted in inquests?
Well, we started with the Ahmed Timol matter, half a G. I oversee the half a G matter. I've put in the memorandum for Dr. Neil Aggat's one, and then we laid a foundation for what will develop in the future. At that stage, all 15 people of the Crimes Against the State, the CATs of DPCI, were helping us. So we had about 15 investigators helping us. And that turned into eventually Shabnam Singh outfit now, where 30 people have been appointed, and it's a whole new setup there. But we laid the foundation and the groundwork for that.
So you agree with Mr. Soni's statement that under your leadership, the prosecutions turned a corner?
Yeah, a bit, yes.
Thank you. And then you were referred to the Rodriguez matter and the fact that Mr. Kaji intervened. He became the 4th respondent and then introduced the issue of political interference. And then you were referred to a judgment, a quo, that found or made a finding about political interference, and it was put to you that it may have relied on yours and Mr. Kaji's evidence. Do you confirm that the other parties or respondents were the Minister of Justice and Correctional Services and the Minister of Police in this matter?
And that matter is correct, Commissioner.
Did they, when the issue of political interference, deny or admit or indeed engage with that issue at all?
No, I don't think they responded to that at all.
In fact, can I take you to the bundle from the Minister of Justice? It is the bundle that they were going to use, or at least gave to us to use for your cross-examination. The document to which I wish to refer you is the answering affidavit of the 2nd respondent, starting at page 17.
Thank you.
May I ask that you specifically turn to page 19?
I'm on page 19.
I just want you to note or at least expand on what it is you make of these. Do you accept that at paragraph 8.2, the deponent on behalf of the Minister of Justice gives an indication by referring to the issue of political interference that they were aware of the allegations that there was political interference?
I agree with that, Commissioner.
You go to 8.3, you go to paragraph 9, they say, applicant has not, in this application, set out how any further details of the political interference would affect the outcome of the matter. So, again, I just want you to confirm that they are aware of it, but do not deny it, do not admit it, do not deal with it, except to raise it as an issue that was not proved.
I agree with that, Commissioner.
So, to close off that loop, the Minister of Justice could have addressed this and denied it and chose not to, or
Correct.
failed to do so.
Correct, Commissioner.
Thank you. Those are my questions, Chairperson.
Thank you. Mr. Salukazana, we've got the speech by Dr. Pretorius, marked 10 years on. What exhibit number are we going to allocate to it?
Chairperson, may I ask that it be marked as if a continuation of the supplementary affidavit, and that affidavit went up to JPP 9, so I'd ask that it be marked JPP 10.
Thank you.
Thank you.
Thank you.
Thank you, Chairperson.
Dr. Pretorius, we thank you for having made yourself available to give evidence before this commission. Your attendance is greatly appreciated. You are now excused as a witness.
Thank you, Chairperson. It was a privilege. Thank you.
These proceedings are adjourned until tomorrow at 10 o'clock.